Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And with me today is Mr. Joe Neerman of Good Lawgic.
Hello, how are you?
Good, man. Welcome back. Welcome
Thank
back.
you.
Happy
Thank you.
to
I'm glad to be here for part two.
Yeah, I'm glad you're here. I was a little disappointed to find out that you did not spend your entire day watching some weirdos make arguments, but
Yeah,
I did.
I, I was having less fun today. So you were having all the fun sitting there and just watching this Southern Baptist preacher getting up there and explaining to us how obviously the Constitution requires that anyone who's left office should be impeached.
Yes. Yes. But real quick, I want to get this super chat because it's not showing up in my stream activity. So I want to make sure I hit it now before I forget. Bad Vibes says, "Hey, Rackets, were you the boomer lawyer that had the cat filter kick on during a Zoom hearing?" No, I was not.
That was great.
Probably not. You would have started the VTuber app instead. Yes. My anime avatar would have come on and started doing dances for bits from the judge. That was pretty funny. My favorite line is, "I'm not a cat." Oh, thank you.
I actually quote tweeted that, and I was like, "This is me trying to edit videos. This is based. This is what I'm like. I'm like, wait, I'm not a cat."
Yeah.
So,
thank you, counselor, for letting us know that cats are not actually talking beings that do Zoom meetings to defend clients. We appreciate.
I hope they took judicial notice of that. That no, this attorney is not a cat.
Yeah, judicial. Your Honor, we'd like to take judicial notice that opposing counsel is not indeed a cat. I would have run with that joke.
Like, that'd be awesome.
You get to break the tension of the room, have a little smile. That's a good play, I think.
Yeah,
he did say he was ready to proceed. That was before he said, "I'm not a cat."
He's like, "All right, let's go. Look, this is all being recorded.
Let's do this."
He didn't seem that cool and collected that he could have like come back with a joke like that where he started licking his own paw.
Yeah,
no. I wonder if the filter actually would have had a paw.
I bet it would. Hand. I bet it would have. God, I would have nailed it. That would have been so much funnier. Let's do this. Meow.
That's good times.
Oh man. So I'll give you a basic rundown of what happened.
Okay. Thank you.
Jamie Raskin gets up and opens. And he cries at least 4 times during his opening argument, which is embarrassing.
There's a lot to cry about.
Yeah. For one, he's Jamie Raskin. So he cries a lot, and he gives a very emotionally charged sort of argument. It's not really great, but it's not bad. It's put together well. And they play a highly edited video of Trump and the riots. And the problem with the video that, I'm not going to criticize Castor and Showen yet. Problem with that video is, of course, it establishes very firmly that Trump is still talking well into the Capitol being breached. Like, right. And that's in the video. They're like, they're showing all this Capitol breach footage and stuff. And it's like, it cuts back. Trump is still talking. I'm like, well, there you go. He didn't incite the riot. You nailed it.
Right. Case dismissed right here.
Yeah. But he does his thing. It's highly inflammatory video, but it was well produced. Apparently it was revealed that they hired some Hollywood movie studio to do it, to do their stuff. So there was that. Then the Nagoose, I think is the guy's name. He gets up there and he does, the Southern Baptist preacher thing. And talking about how obvious it is that they were impeaching former officials, specifically laying out how that's what England would do. That was his argument.
And everything about our judicial system is taken exactly from England. There's no difference at all. I mean, even the way our government is structured, everything is exactly like we have the same the same system. Why wouldn't we follow their rules?
Yes, especially those non-judicial prosecutions that were allowed in England, because in England you could impeach anybody. You didn't have to be. You didn't have to hold office at all.
And I think they allow bill of attainder also. I think you could basically do whatever you want, and it almost sets up the defense with like, yeah, okay, fine. Everything about this is what the English would do, and not what the Constitution says we're allowed to do.
Let me put an asterisk by what you just said. Should have set up a competent defense.
Okay.
Should have set up a competent defense.
Are we up to their defense yet, or we're not?
No, we actually had a third impeachment manager, Carsigli or something. I don't know where he's from. I don't care. He had a really raspy voice and was kind of annoying and really hammered home the same sort of thing. It was very emotionally charged, kind of bland. Not a great argument, but at least well spoken and put together. His voice was annoying, but he was fine delivering his message. His voice isn't his fault, I guess. Then Castor gets up.
Just before you start, tell me he opened with the St. Vitus dance and the dancing plague. Tell me he did that.
No.
Because I gave it to him. I emailed it to him. I said, check out this link. This should be your speech right here.
No. He didn't open with that. Castor wasn't supposed to open. Schoen was supposed to open. And they switched roles. And they scrapped whatever argument Castor had. On the fly. You can tell. I found out they switched roles later. I didn't know that during the live stream, but I was reading up on it. And it turns out that Schoen was supposed to go first. Castor was supposed to go second. But you could tell from Castor's argument that he had no plan as to what he was going to do. He took forever to get through it. I think it was about 30 minutes. It felt like 5 hours. And it was pause and getting way away from the mic over here and then way over here. And it was awful. It was abysmal. Not just the presentation. There was no substance. I can't comment on the substance of his argument because he didn't make one. It was literally an appeal to, he eventually got to the point where they condemned the Capitol riots and they condemned everybody involved with them, which they had to do. I know that's in the brief. That he should have just read part of the brief is what he should have done.
That's what I was about to say. Why not just, if you're on the fly, you got this whole great 78 pages. It took us 3 hours to get through it. Yeah. And we got through 20 pages. Why couldn't he just spend 15 minutes highlighting some of the best parts of the arguments that we're probably going to get to today and just read it? Just bloody read the thing.
He should have. And at one point, Schoen actually does go, from what I recall, word for word from the brief on one of his arguments. And it was great. It was really well done because they wrote this brief. We were commenting yesterday on how well put together the brief is. They wrote it in a very conversational speaking style. It's straightforward. It's not academically written. It's written persuasively, and it's written, you could read it and it would sound like a persuasive speech. Schoen does that.
They could have made fun of Stacey Abrams' bridge work. They had so much material to work from that 78 pages. And instead they're like, oh, we don't know what to do. We don't know what to do. We didn't expect that they were actually going to put together some sort of argument in the beginning. This is what I don't understand. This is what I don't get. What did they think that the House managers were going to start with? What your job? We talked about this yesterday. When you're a lawyer, your job is to play the manager of the team, and you're supposed to put your team in the best position to win. That is your function. That is your role as the attorney. You want to maximize your client's ability to win, and part of that is you have to look at the other team, you look at what they have and what they can bring out to offer. That's why you don't bring in the lefty if you know that they have some lefty reliever in there who no lefties can hit. It sort of becomes like a strategy where you sort of understand, we know what the other team has, we know what they're working with, and we're going to use that and employ that, and that's going to affect what we're going to do so that we can put our team in the best chance to win. What did they think the House managers were going to do if not try to play the harp and the violin? The violin. Play the violin and talk about all the dead people and how Trump was sitting there saying fight, fight, fight 18 times. This is all stuff that anyone in junior high school knew they would do. And that's something you're supposed to be prepared for. What do they have to adjust for the last second? That should be something that's what they're going to do. How are we going to respond? And I don't understand that at all.
Yeah, and there was not a single the only mildly surprising argument that they had was going to English common law pre-constitution for impeachment. But to me, I mean, that's simple. Yeah, the founders had that, had that knowledge base, and that's why they have the Bill of Attainder section, which we've already briefed and are discussing right now. Like, you killed it. You crushed the argument right there. They don't want legislative prosecutions of private citizens. So while we respect that the founders knew about that, we agree that they knew, and they actually mitigated it when they drafted the text. Obviously.
You might have torn down George Washington's statue, but there's a reason that there was statues of him, and that's because we were breaking away from England and their tyranny, and not just allowing them to not want to live in an environment where we have a king who decide who they want to punish willy-nilly.
Yeah,
and that's exactly what you respond with, and it's staring you in the face. I mean, I don't know if they were nervous.
I don't know.
Thinking straight.
Castor was so bad. I actually would encourage you to just maybe pull up. I mean, my stream's still there, or you could pull up any. I don't know where else to find it. That's why I mentioned it. But just
your stream is great. That's what I was watching today for the 15 minutes that I called.
Yeah. And just watching Castor's performance, if you can stomach a few minutes of it, because it's so embarrassingly bad that I don't know what happened. Like, I don't know how it could have gotten that bad. I have winged arguments far better than that one. It's like, what are you doing?
Now, to be fair, to be completely fair, I mean, the stress of that moment is such a high level stress. You're standing there in front of 100 senators with millions of people watching you. So winging it on the fly there is probably not the same as you or me being in front of some tree law judge and trying to explain why elm is, better than oak or whatever. But is it better than oak? Because that's your thing. I don't know whether elm.
No, I think oak is better than elm.
Oh, yeah, that makes sense. Everyone uses oak tables. You never hear of elm tables. But
yeah.
So the bottom line is, it's not the same sort of pressure that you or I under when we're sitting there. Even if you're in federal court and you're in front of a federal judge, it's not the same thing like being in front of cameras where millions of people are watching. You're literally being watched around the world. So that is a different kind of pressure and a different kind of stress. At the same time, A, these are guys who are supposed to be able to handle it. And B, why are you under such stress when you should have predicted all of this is coming in the first place? This is not, I mean, even English law, you and I were able to sit here while the plaintiffs are presenting an argument about English law. You lean over to your counsel and you're like, okay, we didn't think of this. How are we going to respond to this? And you can sit there whispering to each other, writing notes to each other, or texting each other on your phone, and basically saying, okay, let's, Google make sure that Bill of Attainder was something that was permitted in Old England, and therefore we have our argument set up for us. And you're done. And that's it.
Yeah. Very, very, very simple ways for highly capable people to deal with this situation. And Castor did not. Then Castor gets done. Schoen gets up. And it was like, oh, please, dear Christ, be better than Castor. Just be better than Castor. And he came out very fiery, basically calling the impeachment a witch hunt, which it is, and doing all that stuff, and how they're besmirching the sacred honor of the impeachment and the grave duty before the Senate and all that stuff. Even points out respectfully that Leahy is presiding over, even though he's voting, which is a little bit weird for this whole thing to happen. But it takes him like 20 minutes to do that. And okay, yeah, you get what? When you argue, you get what? 10 minutes, right? You get a 10-minute argument?
Yeah. Sometimes they'll break it up. They'll say, if you're like the plaintiff, they'll say you can have 8 minutes in front and then take two
on rebuttal
and reply.
Yeah,
and rebuttal to the thing. But yeah, they basically give you 10 minutes. And I guess maybe sometimes if you have too long, it's almost like when you have no page limit and you just start rambling at a certain point.
Yeah,
So
and
maybe that made it like a little bit more difficult for them because they had 6 arguments and like how do we drag this? You gotta stretch it out. And you don't
right.
want to talk slow.
Well, the
So
well, Castor had no problem talking slow. That was the other thing. His whole argument was broken up, and then he would start another sentence,
oh my god.
and then lots of
Oh no.
pausing. Oh God, it was bad.
Oh
So
no.
the reason I bring up that it's 20 minutes for Schoen to get through this intro is because your normal argumented time that's allotted
He's 10.
is 10 minutes. 30, I think, if you're before the Supreme Court. And so he used almost an entire Supreme Court argument section to just introduce. And there's no interruption here. Like, this isn't, in court, you might get a judge who's going to stop you and say, well, wait a minute, what about this? None of that happens. These guys are just going. So he spends 20 minutes on this hammer blow sort of approach. And that was just bad. That didn't work out very well at all. And then he finally got to his constitutional argument. And that's what I wanted the whole time. Like, please, they did an emotional ploy. Great. Now you get up there and say, the adults are in the room, and we're going to talk about, look, we recognize the emotion, but we're here to talk about what the law is. We're lawyers. We're not crybabies. Right. And so here it is.
There's a very old adage that litigators are taught, which is, if the facts are not on your side, you argue the law. If the law is not on your side, you argue the facts. And if neither on your side, you argue your head off. Right. And they had the law. That's what you do. You just pound the law. The facts they're admitting that the facts are terrible with respect. I mean, the facts are not really terrible when you consider as far as incitement and did he incite them. And those are facts that they could have played up. And especially like you said over and over again, for the last 2 days, all I've heard you say is that 19 minutes, he's still going on. It's the whole thing's happening. I mean, that's a powerful fact. That's a fact which, like I said, when you said that, I'm like, yeah, case dismissed. Move on. I mean, it could not be incitement. But
in a criminal court, this would have been laughed out for incitement. Like it would have been pretrial dismissal, no problem. Wait, so they breached the Capitol before he was done speaking, and he's 30 minutes away by foot, and there are no cars permitted on that road? Okay,
and he's the murderer. Yeah. It's like, he was off in Thailand when it happened, but he's the murderer. No, we look at the facts. It could not possibly be. We're done. Everyone go home.
Right.
But
so the law was absolutely on their side. They should have when Schoen pounded it, he did really well. The problem is you've already sat through an hour and a half of Democrats. You just sat through a half hour of a rambling Castor with no plan. And then you sit through another 20 minutes of Schoen. So you've got 50 minutes after the break before they get to the meat of their argument. And it's like, Schoen should have gone first. Oh, that's another thing. So they changed their strategy so Castor could go first and quote unquote diffuse the emotional rhetoric of the Democrats. They had a 15-minute recess. The emotion was gone from the room. People are coming back in after going to the bathroom, having discussions, grabbing drinks or whatever. They come back in, they sit down. You don't need to diffuse anything. You had 15 minutes. People already forgot what they said. Like, this is Congress. They're like ADD cats. They honestly have no idea what arguments were just made.
And that ADD is exactly why you cannot wait 50 minutes until you bring your best argument out.
No.
You start with your strongest. This is not like, this is different from like a baseball team where you leave your cleanup hitter for batting fourth. No, you start with your best, most powerful thing, and you come out there and you say, this is why this is all a waste of time. Here's what the law says. Boom. But as a side note, here are a dozen other problems that they have with this. And yeah, it's true. What happened was a tragedy, but trying to find a reason that we should tie this into Trump and blame him is pretty ludicrous. And the only reason they're doing it is because it's a ninth try of them trying to do it. And that's how you come forward. You don't sit here introducing, you sit here saying, oh my, I can't believe that there was such a terrible tragedy that happened there. No, you don't have to overplay that. I mean, we recognize it, we admit it, and it's terrible, but that doesn't mean that we have to sit here and impeach the president as if it had any relationship to him, because it obviously didn't, based on the fact that there's 19 minutes for them to get from him to there. And the law is that this is a bill of attainder. This is something that you're not supposed to be impeaching someone who's not removed, who's not no longer in office, and we're wasting everyone's time here. And it's a shame that what happened, but that doesn't mean that we should waste everyone's time and make and just deunify and divide the country that much more over trying to find a reason that we should pin blame for this on Trump. And that's really
Yeah.
and I don't understand. I'm telling you my theory. My theory I was telling you before. Should I share that with?
It's up to you.
I mean,
this is a place of freedom
okay.
of opinion.
All right. So as I was expressing to you before, you're too young to remember the Dallas Cowboys in the early 90s.
Well, I mean, okay? I remember them. I just didn't know what was going on behind the scenes. I mean,
right. Okay.
My uncle actually bartended at or managed a place called the Hofbrau there in Dallas, right by the Cowboys Stadium, and the Cowboys would always go there. So, like, he got to hang out with like Emmitt Smith and Troy Aikman and stuff like that.
Emmitt is the greatest running back of all time. Just letting you know that.
Look, I'm gonna disagree slightly because I'm an Earl Campbell fan.
All right, so I don't know how you can be an Earl Campbell fan when he's like 40 years before Emmitt Smith, and you're too young to remember Emmitt Smith.
I met Earl Campbell.
Oh, okay, fine, yeah. So you met Old Man Campbell, and you're a fan of his. That's great.
No, I was NFL like 6. Fans, he wasn't that old yet. Here, check this out. Here's my autographed Earl Campbell jersey. Even.
Ooh.
I have an autograph.
I'm just gonna point out.
Hat and picture. He sent me his barbecue sauce. Like
Yeah, no, that sounds like he was just a stud. Look, he obviously has. I never got to see Earl Campbell very much. All I'll tell you about Emmitt Smith before I get into my analogy here is that man on week 17 or 16, the last week of the season, playing against the Giants, the winner takes the division. And he ended up rushing for 160 yards. And they found out after the game, he looked banged up the whole game. He played the entire game with a separated shoulder.
Yeah.
They gave him the ball 30 times with a separated shoulder, and he ran for 160 yards because he was a warrior. So, but
I'm not here to besmirch the good name of Emmitt Smith. He was a titan on the field. Don't get me wrong.
Yeah.
Don't get me wrong.
Yeah, no, he was phenomenal. So what I was going to explain to you is maybe you were too young to know the whole business end of things. But when Jerry Jones bought the team from Tex Landry, I think Tex Schramm, I don't remember. Tex Schramm. He bought it from Tex Schramm, and he replaced Landry was leaving, and there was a whole turnover in the late 80s. The Cowboys were a mess. And one of the first things he did was he brought in Jimmy Johnson. And they made a great trade where they traded Herschel Walker away, and they got all sorts of tons of picks. And they made some great draft picks, built a phenomenal O-line, got Aikman and Smith and Irvin, the Troika, and they started winning. And after they started winning, so Jimmy Johnson, who was a real alpha, he would basically boasted about how he took this trash team and turned them into the most dominant dynasty that the NFL had ever seen. And Jerry Jones was really mad about this. He got really upset about it, that all this accolade was going not to him because he felt that he deserved it.
Right.
And because of that, he gets into a fight with Jimmy Johnson, and he ends up firing him, and he places him with Jimmy Johnson, who had been from Miami, I think he was Miami Hurricanes, and he replaced him with his arch rival Barry Switzer, who was a boob as far as a coach compared to Johnson. And even the team was so loaded by that point that even Switzer managed to win a ring, although he blew another year. But I'm not going to talk about that because I'm still bitter about it. But yeah, and then Switzer ended up showing his incompetence. And every coach that he brought in afterwards, every coach was a beta. He was like someone who Jerry Jones could easily dominate. From Jason Garrett, everyone he brought in. I think he had Wade Phillips at one point. They were just people who were going to kiss up to him and do whatever it is he wanted, and never ever try and deflect any credit from Jerry Jones. Sure. And you need a real alpha to be a leader of your squad. You want a leader of a squad. You want a real alpha to be there. And the Cowboys have stunk ever since. They can't win a playoff game. Even with Tony Romo, they couldn't do anything. They fell apart. And that's the similar thing that I smell with Trump. Excuse me, that with Trump, I feel like he doesn't want a real alpha dog running his legal team. He wants someone who is going to kiss up to him. And that's why you end up getting these people who are like, oh, we didn't know that this was going to happen. What are we going to do now? And they're lawyers who are maybe your corporate attorneys who are probably litigators. I'm sure they have a history of litigation, but they're not the same alpha dog that we saw from Sekulow in the first impeachment. They're not the same. They're not the type of alpha dog. They're not your Dom Draper type of character who, when they walk in a room and they start talking, you feel like, wow, it's his room and he's got to be right. And I'm an idiot if I disagree with him. That's the confidence and aura that a real dominant alpha attorney walks in with. And we haven't seen that from any of his staff.
No.
And the only reason I can understand, the only reason I can imagine why that would be is because Trump, for one reason or another, doesn't want to deflect from himself to that. I mean, I love him as a president. He's a phenomenal president, but I look at this as a shortcoming in him that he's almost maybe perhaps intimidated from having an alpha attorney like that who's able to run things for him. And it's showing in the production from what we're seeing in public is from his litigation squad.
Yeah, and it does seem like that. Again, I don't want to say Schoen did a bad job, because once he got warmed up, once he got into his constitutional argument, it was really a good constitutional argument.
Okay.
But it took way too long. And as proof of how bad the Trump lawyers did today, a Republican actually switched his vote and voted that this was a constitutional process.
I heard, instead of it being 45 Republicans against, it was now 44.
Yep.
Who switched? Who was it?
Some guy from Louisiana. From Louisiana. Really? They lost a Louisianan on this.
Wow. Wow.
It's not really like scary. They lost McConnell or Cornyn or something. McConnell and Cornyn both voted no. Right. They lost a Louisianan.
Wow.
Which was just...
that's astonishing. Yeah, that's astonishing. If you're from Louisiana, you know you have to go red, otherwise you're never going to reelect it.
Yes.
And there's tons of Trump fans down there. That's kind of like bizarre that they wouldn't just, click red without even thinking about it.
So yeah, it was.
And look at you and me both wearing red, by the way.
Exactly. We're showing solidarity.
There you go.
Yeah, it was Cassidy from Louisiana.
Mm-hmm.
Okay, so someone asked a very good question, and I want to hit it because it's perfectly timed. And it was Word Son for Reals says, does any of this matter? Doesn't the entire room already know how they're voting? Well, we learned today that no, they don't, because we had a Republican change his vote, which means, and this is something I think I mentioned yesterday, that yeah, the Republicans did vote on, I either mentioned it yesterday or at the beginning of the stream today. I don't remember. But the Republicans may have voted that it was unconstitutional, but the Senate overall voted that it was constitutional, both at Rand Paul's procedural vote and today. So now the Republicans have technically the cover to say, well, I didn't think it was constitutional, but it was because we voted that it was. I disagree with that, but now they do have the ability to go ahead and cast a vote in a different way than that opinion. And they'll get flack from their voting base or whatever, potentially, but there's nothing binding about either of these two votes. And we know now that certainly at least one Republican is swayable. If one is, then 17 are in theory. It's a long road, but they certainly could do it. And if Trump's lawyers don't put up some kind of fight, I mean, if they don't show that there's anything, like, here's what you don't want. You don't want these lawyers presenting some incompetent babble, because if you're going to vote for it, then you look like a partisan. Yeah.
Yeah. You have to give them something to hang their hat on. You have to give them something that they can basically say, look, this point that they made about X, they're right. And I can't, but if all they're doing is being incoherent and just moving from one direction to another, and you can't even hear them because they're talking like a pendulum swinging back and forth, in that case, you look like a hack. And no one wants to look like they're in the tank and that they're not reasonable. Everyone wants to look reasonable. And that's why you need to give people who want to believe in you a reason to believe in you. And this is so much here. There's so much meat here for the Republicans to work with, because this is a ridiculous impeachment. The whole thing is ridiculous. I mean, the whole notion that he's being impeached when the whole purpose is to remove someone from office. That's why we have it. If it wasn't about removal from office, you can always bring civil penalties against him. Even right now, in theory, they can go and there could be criminal charges brought against him for inciting a riot. There's no reason they can't bring that against him.
There could be criminal or civil charges as well.
Yeah, he doesn't. You know what?
He doesn't have immunity.
Yeah, Sicknick's family could go after him and say, you know what, that our relative here is dead because you incited this riot to go in there, and the obvious repercussion was that some people can get hurt, and he was the victim. And
I mean, heck, I don't think they would all succeed, but I think you could make a plausible claim for everybody who died, even the people who died from medical emergencies, where they say, hey, you were constantly flaunting COVID. We should have social distanced because people didn't social distance. My family member was crushed to death in the crowd and the ambulance could not get through to administer aid. You're partly responsible for that death. And I mean, there are civil remedies. Again, I don't know that you could actually prevail on that theory, but you could certainly ruin someone's time with a civil case on it.
And I'll go one step further, if you allow me for a minute. If your counsel for that woman who got shot, Ashley Babbitt. Ashley Babbitt. If you're her attorney seeking wrongful death damages, you must name Trump.
Yeah.
You have to, because you're committing malpractice if you don't, even if it's like a weak claim and whatever, with all this circus going on where he's being cited for allegedly inciting this. So if you don't bring it, their family would bring a malpractice suit against you that, look, here's something that we could have possibly had a deep pocket, who could be held liable for this entire thing, that the only reason she's there is because Donald Trump riled her up into thinking that this election was fraud. And yes, even though it was fraud between you and me, if you're an attorney, you get up there and say, he's wrongfully alleging that there was election fraud. Because of that, she's standing in she ended up in the Capitol, and he kept saying fight, and that's why she's there, and she got shot and she's dead, and it's all his fault.
Well, even if they don't name Trump, it's highly likely that the other party has either required or permissive joinder of Trump as a party.
Yeah.
Right? Like you at least would petition the court and say, no, we want to add Trump. He's got deeper pockets and we can put all the blame on him. Yeah. I mean, if I'm representing the defendants in that case, I'm definitely going to try and add Trump to that case.
You're right. And that's part of it. And that's the sickness of our judicial system when you think about it as far as what's ethical and right. It's really kind of sick because really she was there out of a love for Trump, presumably.
Right.
And now her family will end up suing Trump over that because the result that happened here. It's kind of a backward thing about our legal system. But if you're their attorney, you have no choice, or your defense, like you just brought up, you have to bring them in there. And I'll tell you this much. I'd be surprised if it doesn't happen. It's going to happen.
Yeah. And Monkey D Cam says a trigger happy cop murdered her. Actually. Yeah. But it doesn't matter what happened. This is lawsuits. It's who you can blame. That's the trick, is who you can blame, and whether or not you're able to prevail over Trump in those things. You're going to their lawyers are still going to be looking to add him because that's their job. And it's a dirty business in that way. All right, should we jump into this? Should we get back into this document?
I think do your super chats and let's jump into the document, because you said you don't have notifications about super chats. I don't want you to.
No. I've got them now. It was just that first one.
Oh, okay, fine.
So
if you whatever you want, I'll follow your lead. You tell me what you want.
Where did my document go? It's not showing up. Give me 1 second, and then there it is. Okay. Oh, it's going to be weird for just a second. I got to adjust the size. Woo! Way too big.
Right.
There we go.
Don't make it awkward here, okay?
Yeah. Way too big. Got to adjust the size. Okay, here we go, guys. So we're going to try and get through like the majority, if not the rest of this. So we're going to go quick. Constitution only gives the Senate jurisdiction over the president, not the former president of the United States. One legal scholar described the simplicity of Article 2's limitation, which House managers try in vain to make seem inscrutable, in this way. Quote,
which page? Where are you? What page are you on?
Page 17, subheading 2, bottom 2 paragraphs.
Page 17, numbered 17?
Numbered 17, page 20 on the PDF.
Got it. Thank you. Go.
Okay. Quote, a half-grown boy reads in a newspaper that the president occupies the White House. If he would understand from that that all ex-presidents are in it together, he would be considered a very unpromising lad. This is the first reason why a former president cannot be impeached. He is not the president anymore. As Professor Philip Bobbitt, one of the leading scholars on the impeachment process and author of Impeachment, a Handbook, recently argued, quote, there's no authority granted to Congress to impeach and convict persons who are not civil officers of the United States. It's as simple as that. But simplicity doesn't mean unimportance. Limiting Congress to its specified powers is a crucial element in the central idea of the U.S. Constitution, putting the state under law. Further textual support on this issue is evidenced by the founders' use of shall when identifying the penalty to be imposed, i.e. shall be removed from office. Justice Scalia once wrote, when the word shall can reasonably be understood as mandatory, it ought to be taken that way. In 2007, the Supreme Court confirmed that, quote, the word shall generally indicates a command that admits of no discretion on the part of the person instructed to carry out the directive. Black's Law Dictionary, 1375. As used
Texas
in
versus Pennsylvania. You shall hear this case. We're going.
Yeah.
Sorry.
As used in statutes, this word is generally imperative or mandatory. The text then is very clear. Conviction at an impeachment trial requires the possibility of a removal from office. No, it requires removal from office. That's a misstatement there, because it says they shall be removed if they're convicted at impeachment. Without I see what they're saying though. Without that possibility, there can be no trial. So they're saying if you can't be removed, you can't have a trial. Can't be removed if you're already gone.
If you cannot be removed upon conviction, then you cannot have a trial. I agree with you. It's a little awkwardly phrased, but yeah, that's the point they're making.
In the civil law analog, this case would be summarily dismissed under Federal Rules Civil Procedure 12b6 for failure to state a claim upon which relief can be granted. Yes. The second reason a former president cannot be impeached follows logically from the first. The purpose of impeachment is to remove someone from office, and unequivocally, this impeachment trial is not about removing someone from office. As Mr. Trump left office on January 20th, 2021, he is now both factually and legally a private citizen. House managers have no authority to legally redefine former presidents as presidents for some constitutional provisions and not others. Would they accept a former president conducting foreign policy on behalf of the United States? Would they be content to have a former president nominate a justice for a vacant seat on the Supreme Court? Of course not. That is why the term former president is actually a term of art with legal ramifications, as evidenced by the Former Presidents Act 3 U.S.C. 102 note, which states that, as used in this section, the term former president means a person who shall have held the office of President of the United States, whose service in such office shall have terminated other than by removal pursuant to Section 4 of Article 2 of the Constitution of the U.S., and who does not then currently hold such office. This is a good catch here. Mm-hmm. It's always good when you can point to a statute that clearly defines the legal term that you're using and say, no, we actually have that statute that defines this, and they're not even paying attention to it.
There's no confusion as to what the difference is between a president and former president. It's actually right there if you open the book and look at it.
Yeah. I think this was bait to get them to argue that he is a president. That he is a president because he was president at the time of conviction. I think they wanted that argument in some way.
I never understood if they're allowed to do this now
at impeachment. Sorry, go ahead.
Yeah, but I'm saying here's the thing: if they're allowed to do this now, would they also be claiming that they're allowed to file the articles of impeachment today? Like, let's say they hadn't filed it so rushed. Are the plaintiffs are the Democrats claiming that if they had not gotten it done before January 20th, they still be allowed to impeach him today?
That argument hasn't come up, and that bothers me that it hasn't.
Right.
Uncivil Law and I were talking about this during the stream. Is what we want to know is, since the articles weren't delivered until after inauguration, was he impeached before or after inauguration? Which one is it? Now, in my coverage of it, I've just been going with the Democrats' default assertion that he was impeached at the time they passed the resolution to impeach him.
Yeah, but that's not trusting Don Lemon for the news. Yeah.
Right. It's just simpler than having to explain the argument every single time. So you just kind of run with it. But there is a real question there. Was he actually impeached prior to leaving office or not? And they should be having this argument. They should be hashing this out, and they're not doing that, and that bothers me because you can argue he's been impeached as a private citizen, not as a president, and make them justify, no, we impeached him as president. Then you say, okay, well, if you impeached him as president, how do you get to change his status and not have the Chief Justice preside? That should be unconstitutional as well. Like, hang them on this argument is what I like at every single turn is what I would think would be part of the process. And they didn't do that.
Nick, that's a genius argument that I never considered before.
No, right. Well, thank you.
You're right. No, I'm telling you, that's a really clever and appropriate argument that they should be making. This way, get them back on their heels. Make them start talking about law. Make the Democrats actually defend the legality of what they're doing here, rather than just making it like, so many people are dead. Make it about hey, look, this is a trial here. Let's talk law instead of just pretending that we can do whatever we want because people are upset about a calamity.
To highlight how bad the Republicans did in one other way that I forgot to mention earlier, the Democrats gave back 30 minutes of time. They had a 30-minute time reserved, 33 minutes of time reserved for their rebuttal, and they didn't use any of it.
Oh, wow.
That's how bad the Republicans did today.
By the way, that's a genius move by the Democrats. You got to tip your cap to them.
Oh,
tip your cap.
Yeah.
They're like, you know what? What you just said there, enough said. I'm good with that. Yeah.
Yep. It was bad. Bad Vibe says, so in regards to the Rittenhouse case, the 3 individuals that became lead sponges could sue Waters, AOC, etc. For becoming worm food, and the third becoming a one-armed man. Possibly. They possibly could. I don't know if it's as direct of a connection. The advantage you have with Trump is there's a bunch of press about how he's responsible, and so you have a crack at it. For the others, you don't have as much press support. You can't cite a bunch of articles and legal opinions as to why they're responsible like you can with Trump. So, again, not saying that he is responsible. It's just that's the legal argument you would make.
If you're Ashley Babbitt's attorney, you will be quoting the House Democrats from here in your legal argument. When you're presenting your legal argument and in your brief and all your arguments, you'll be quoting these statements that are being made in this impeachment to tie a nexus between her death and Donald Trump.
Yes, and you'll be quoting the constitutional scholars, the 150 of them who wrote that letter. You're going to quote that. You're going to quote all the sources that these guys are quoting as it relates to incitement and high crimes. Like, you're going to do that because even though it's not a criminal case, Trump walks out the door easily. A civil case gets a lot muddier because of the standard being so much lower, and he can be just partially responsible depending on what state they sue in. Mither and Emmer says, good to know SCOTUS wants shall to be mandatory. They sure have demonstrated it when they discussed the phrase shall not be infringed. Oh, wait. Yeah. All right. Going back, as it relates to the above definitional requirements, Mr. Trump has held the office of the President of the United States. His service was not terminated by removal pursuant to Section 4 of Article 2 of the Constitution. And even if this sham late impeachment were to result in a conviction, he still would not have been thus removed. And he does not currently hold such office. He is therefore legally in the same category as former president and is statutorily not the President of the United States, referred to in the impeachment clause of the Constitution, the text of the Constitution that provides that only, quote, the President, the Vice President, and all civil officers of the United States shall be removed from office on impeachment. Supports the conclusion that the impeachment process applies only to officials in office. This provision does not state a president or a former president. It unequivocally states the president. And when one refers to the president, the reference is clearly to the current president. The text of the Constitution simply does not contain language allowing for the impeachment of a former president and does not address late impeachments, i.e. an impeachment of a former officer. Any inference from British practice about former officials is therefore a nullity because they would impeach private citizens, and our framers decided not to do that. We chose not to remain British after all.
How did they not read this?
I don't know. He should have just put that, like, just read that paragraph and, Castor, page 19. Just read that.
Yeah, like how do you not? It's like you just say, look, we call it. We don't put mustard on our French fries. We don't drive on the left side of the road over here. we're not British. We're not in Britain here. We don't say God save the Queen. And they have it here. They have it here. It's like they didn't read their own work. This is such an
Yeah.
They choked. They choked. That's basically what it is. They choked. That's the only explanation.
Yeah, I think I don't know how. I know you were talking about the high pressure they're under. They're in front of millions of people or whatever through television, but I don't know how you're at that level of the game and you choke. Like
yeah.
Cuz like you have a job, and that job is to, I don't care how many times you do your stupid 2-hour long speech, you do it as many times as necessary so that you don't choke. And you don't under any circumstance change your plan in the middle of this type of proceeding, because there's no reason to change your plan. They're not going to come up with a legal point that the judge is going to go, oh, if you don't rebut that, this case is going their way. Like that's not going to happen. It's entirely political.
And it's an embarrassing admission of lack of preparation.
Yeah.
It's an embarrassing, inexcusable. Like, it's an inexcusable lack of a preparation. Like, what, were you busy with a different case? Was that what the problem was? Were you too busy with another case? Did you have, like, did your neighbor's cherry mahogany fall the wrong way?
Yeah.
You had to get tied up with that. There's an emergency.
You have to imagine that these guys know that they have at minimum $500,000 to spend on billable hours in 2 weeks. Like, they have all of the time they could possibly want, and they have a client who can pay for every minute of it, even at their probably advanced or emergency rate that they're charging.
Yep.
And I did read that Castor's hourly rate was $650 in 2016. So it's much higher now when he's representing.
Okay, so like I said, $1,000 an hour.
Yeah. Now that's Castor. I don't know what Schoen's is. I didn't look.
Well, Castor is the top name on the paper, so you'd think that he's the lead attorney. So, and he's also not from New York, so that's why $650 down where he is like $1,000 or $1,200 up here.
Yeah,
right?
He's from Pennsylvania.
He's from Pennsylvania. I thought one was from South Carolina. Was I wrong about that? Was that former attorney?
He's the former Attorney General of Pennsylvania. He may have moved. Come to think of it, because he does have kind of a southern-ish speaking. So I don't know.
We gotta move. We gotta come around here.
Mr. Bentham, I did bring up the poem. It was a joke. Mithran Emrys says the DNC can't have it both ways. If he was impeached as the president, Roberts has to preside. I agree. If Roberts does not have to preside, then he can't have been impeached as the president. Check and mate. Agree. They should really have hit this. This would have been the core of my argument. Bad Vibe says, are these lawyers sandbagging? No, I don't think so. I don't think they're sandbagging.
That seems sandbagging mean like what? Tanking on purpose? Is that what he means?
I don't. There's a lot of ways to look at sandbagging. I always think of it as like just filling out hours, maybe like just delaying, stalling, padding their. Bad Vibes, tag me. Tell me what you mean.
If there's sandbagging, there's no reason to change oars in the middle of the stream.
No. And again, you can justify any number of hours. I mean, they're on a compressed schedule. They drafted a 78-page brief, and it's a highly put together brief. Lots of citations, tons of research went into this. They can justify any expense in the condensed nature of this proceeding. I mean, they were only hired like a week ago.
Yeah.
They can justify.
But I'm sure they brought on every bit of their staff and worked them to like dogs for the last week.
Yeah, I mean the brief looks like they did.
Yeah, and the brief looks really professional. Like reading this is what you found one tiny little missed period yesterday.
Yeah, I saw a missed period.
Yeah, but I mean that's phenomenal considering that they had to put all this together in a week and everything's so well researched and they have all their footnotes here and we're on page 20 and they've got 55. What is this? 35, 55 footnotes over here. I mean they're killing it with their writing style and their arguments they're making. I don't know. I mean, maybe they're just better at writing than they are at oral presentation. There are some people have different skill sets. Maybe they're just not great at oral presentation.
Could be.
But you should have someone else. You can bring in someone from outside who's like, okay, this is the best oral arguer in our state, and he's the one we're going to bring up here. I mean, this is the big leagues. This is, this is the Super Bowl right here.
Where's your Johnny Cochran? Where's your Johnny Cochran? Get him up there.
Yes. Get your dream team out there. The same way they had Alan Dershowitz last time. Get your dream team out there now. And this is whatever.
Yeah. Bad vibes, he meant dragging their feet and being bumbling idiots. I don't think they're intentionally doing it. I think they just got rattled in that they shouldn't have. They had no excuse.
Nobody does that on purpose. Nobody embarrasses themselves internationally like that on purpose.
And Castor will take a professional hit from this. I mean, Schoen is going to get it too, and I don't know that Schoen deserves it as much. Castor deserves the professional hit. This is bad. I would not hire this guy at all. Stupid Monkey Zero says, I can't wait until we impeach Lincoln for inciting the war of northern aggression, or what the left would say, Lincoln using his privilege to be a white savior.
Yeah.
All right, back to the document. The founders knowingly did not extend the power of impeachment to former officials. See, again, they could have just had Castor read this section. The founders clearly decided to purposefully limit the power of impeachment in this way. The concept of a late impeachment was in use at the time the Constitution was written, with Great Britain specifically allowing impeachment of former officials. In fact, the British Parliament could and did impeach private citizens. The framers could have explicitly included a provision allowing for the impeachment of a former president, but they did not. Instead, the Constitution was written to restrict impeachment to specific public officials, the president, vice president, and other civil officers. There's little discussion in the historical record surrounding the framing and ratification of the Constitution that treats the precise question of whether a person no longer a civil officer can be impeached. And in light of the clarity of the text, this is hardly surprising. And this is where they're quoting Bobbitt again. The text is also doubly clear given the clarity of available models of some of the United States themselves that did allow for late impeachments to take place. While the House managers cite to some non-binding statements from John Quincy Adams about the possibility of late impeachment in a case that did not even end with an impeachment, I was thinking that when they brought him up, but there is equal and perhaps even more on the scant record that would weigh against it. For example, as Professor Brian Kalt details, in multiple places, Alexander Hamilton seemed to believe that removal was a required component of the impeachment penalty, which suggests that he viewed late impeachment as impossible. Now, Kalt actually wrote a tweet that said that they misrepresented his paper entirely in this brief.
Right.
So that wasn't helpful.
Yeah. Okay. So maybe one of us should call Castor or Schoen tonight and tell them, hey, the House Democrats are going to bring up this tweet from Kalt. Maybe you should have an answer for that.
They did already. They already did.
Did they already bring it up?
Yeah. Yeah.
Oh,
they brought it up in their argument. Maybe we should just call up Castor and Schoen and say, do you want help? We'll just come in. Just give us $500 an hour.
Yeah.
Do you need some help? In the Federalist number 39, Madison wrote that the President of the United States is impeachable at any time during his continuance in office. Emphasis added. Interestingly, where the Constitution refers to the President in Article 1, Section 3 and gives protocols for impeachment, such as when the President of the United States is tried in the Senate, the Chief Justice shall preside, the Senate reads this as applicable to the impeachment trial only of the current sitting president. Yet under the House manager's theory, they urge the Senate to read the constitutional provision that specifies the president is subject to impeachment to include a former president. Good. Yes. They should have hit this more, I think, even than they did. Historical precedents. The failed attempt to impeach Senator William Blount and Secretary of War William Belknap. And yes, the Democrats both brought Blount and Belknap up, and they just conveniently kind of danced around the fact that neither of those guys ended up being impeached. And I think Schoen and Castor, again, Castor's job should have been, okay, you just refute all of their stuff. Like if he didn't have something that was so important to say, you just refute all of the points that they tried to make and danced around, like this one. Blount and Belknap were not impeached. And part of the reason,
by the way, have you ever had to do on the fly type of rebuttal to arguments that you weren't expecting?
Yes.
Okay. The first time I ever did that was in federal court in front of Judge Haight in the case that ended up being
Judge Haight.
Yeah, it's spelled Hight.
Doesn't
he
matter.
Is from this Southern District of New York.
I would not want to be in front of Judge Haight. Sounds
Yeah.
terrifying.
He was like that guy from the judge from My Cousin Vinny. He was like this older guy sitting up on the bench, and um rather intimidating fellow. I don't know if he's if he's still a judge anymore or not. But in that, I I told my co-counsel I want to rebut their cross their I want to be the one to give a reply to the rebuttal. And what do? This is how you do it. While they're talking, you literally take you sort of make a line, a note that this is the argument they make. Here's my response. And you make a list of like 14 notes that you want to make while they're talking. And then as soon as you get up there, you just sort of read off, you say, my adversary says this, and they're ignoring they're saying X, they're ignoring this part which defeats X. They say Y, they're ignoring this. And that's how you do it. And in 2 minutes, you can sum up everything wrong with their argument and then move on to what you want to say. And it's not something, and when I made this argument, I was a fourth-year attorney at that time. I was not someone who was worth anything like what these guys are worth on an hourly basis, certainly at that point in my life. And it's astonishing. When you tell me that they had to, change rowers midstream here, and everyone's moving around on the boat. I'm picturing like the boat like going from side to side while they're saying, no, you could be the one with the bullhorn screaming stroke, stroke, and I'll be the rower. Wow.
Yeah. No, I do the same thing. If I'm going to if I have any question about the argument, most of the time I don't, because it's been briefed and we know what the other side's going to say. If I have any question about the argument, I'm going to sit there with a legal pad. I'm literally going to write down their exact words, because you always want to put their exact words right back at them. And then I'm going to respond with some point that I either know or that I've looked up in the meantime or whatever it is. I mean, that's just what you do. And they didn't do that at all. Socialism is for figs says, so do you feel this will bite the establishment in the butt in the long run? And you have to remember, this is not a courtroom, and in the room they are in, they probably feel like they are frowned upon by all for the defense of Trump. I don't know that they're that frowned upon by all. They've got 45 people in there who have told them, just tell us this is unconstitutional. Just do that. That's all we need. We don't need you to do anything other than that. And if you just do that, you're going to win. They told him that. And
Nick, how many viewers do you have right this second?
1,200.
1,200. Okay, so I'm telling you right now, 1,150 of them were all on the side of Castor and Schoen. They're not frowning on them. That's my point. The overwhelming majority of people who were Trump supporters, they're not, and there's tens of millions of us. No one was sitting there judging on them. So I don't think that that's an excuse for them. I mean, I can understand why someone would ask that question, that, there's that pressure of, people hate you, and that's true, but people hate the other side also. We're a divided country. That's just the way it is.
And it's important to remember that half of the people a lawyer meets professionally hate them. Roughly, because you've got opposing counsel and you've got opposing parties, and they don't like you because your job is to make their life harder or bad. It's not a friendly profession. And guys who've been doing this for 30 years, it's not like they walk into a room and everybody loves them everywhere they go. I feel weird walking around town sometimes because, I've pissed off other lawyers. I've pissed off other people. And I don't want to run into these people ever again. Like, I don't want to.
My wife pretends she doesn't know me. So.
Yeah. So they should be used to this stuff. I don't think it'll bite the establishment in the butt in any specific way. I think it'll bite Castor in the butt. Maybe not, but I think it should. Bad Vibe says, if Congress rules against Trump, just remember what goes around comes around. I think that's true. I don't think Congress is going to rule against Trump ultimately. No, I still don't think so.
Look, they really would have to screw the pooch pretty badly.
Right.
I mean, that would be a monumental collapse. That would be an Atlanta Falcon type of collapse.
Yeah, it'd have to be worse than the job they did today. And if Trump isn't still on the phone screaming at them, I'm going to be surprised.
Yeah.
To be brutally honest.
I would think that Castor would have been fired before he sat down. Like he's sort of he's probably got Trump in his ear there saying, "You're fired.
You're fired.
You're fired."
terrible. I've seen better speeches coming out of Barron. This is embarrassing. Maybe I should hire him. I could get Barron up there. Barron could talk better than you, much better than you. He's got better words. He's got better points. Your points were terrible.
That's really good. You're really good at that. Wow.
Historical precedents. They failed. Okay, so we got Blunt and Belknap. The House manager suggests there is a congressional precedent for impeaching a former president in the impeachment cases of Senator William Blunt and Secretary of War William Belknap. Problem with Williams, I think, is the issue here. These two cases are actually inapposite and do not provide any binding precedential authority for impeaching a former president. In 1797, United States Senator William Blunt of Tennessee faced allegations of conspiring to help Great Britain seize Spanish-controlled areas in Florida and what is now Louisiana as part of a scheme to pay off debts incurred from land speculation. Blunt was expelled by the Senate prior to his impeachment proceedings in 1798. He therefore argued he was not subject to trial and refused to appear. Specifically, Blunt argued the senators or members of Congress could not be impeached, but only expelled by their respective chamber, and even if senators could be impeached, ex-senators could not. Quote, in a close vote, the Senate defeated a resolution asserting Blunt was an impeachable civil officer, but the debate around this vote and the text of the resolution did not make clear whether the resolution was rejected because it was felt that the senator was not a civil officer or whether, having been expelled, Blunt ceased to be impeachable. Therefore, the case has little or no precedential value supporting a late impeachment. In 1876, Belknap, Secretary of War under President Grant, was investigated by the House for corruption. Belknap had accepted over $20,000 in kickbacks for the appointment of an associate to a lucrative military trading post at Fort Sill. That's a lot of money in today's dollars, by the way.
Yeah, that's probably millions of dollars.
Yeah. However, on March 2nd, 1876, after the House had taken up the issue, but before the House voted on his impeachment, Grant accepted Belknap's resignation, apparently just minutes before the House was set to vote. Despite his resignation, the House voted to impeach him anyway. The issue of whether an officer who had resigned could be impeached was heavily debated from May 15th to May 29th, but ultimately the Senate voted 37 to 29 that it had the power to hold an impeachment trial for a former officeholder and proceeded to have a trial. On August 1st, 1876, Belknap was acquitted because less than two-thirds of the Senate voted for impeachment. While historical accounts suggest that few senators believe Belknap was innocent, the majority of those voting to acquit him did so because they did not think the Senate had jurisdiction to convict someone who was no longer in office. And that's a good argument.
But it is a little speculative. You don't know why. I mean, no one here knows why they voted against it.
Alan Dershowitz does.
He was in short pants back then, and he was sitting there taking notes in the back.
Well, that's who they cited. That's their footnote.
They're saying Dershowitz made this claim as to why they did it. I thought you were making a joke as to how old Dershowitz was.
No,
he was like
that one too.
He was like, I remember this case.
Here we go. Here's Dershowitz's commentary on it. Or no, this is from Hines. This is from Hines. Precedence of the House of Representatives from 1907. An analysis of the reasons given with the vote shows that those voting guilty, 2 believed that the Senate had no jurisdiction but gave their verdict in good faith. Since by vote jurisdiction had been assumed, of those voting not guilty, 3 announced that they did so on the evidence, while 22 announced that they voted not guilty because they believed the Senate had no jurisdiction. One senator stated that he declined to vote because he believed they did not have jurisdiction. And so then Alan Dershowitz reframes the case, probably based on the same book.
But you actually made this argument like 30 minutes ago when you were saying once it's been passed now and recognized that this Senate agrees that we have jurisdiction, it's almost like you can take that from the equation and then we start examining, well, was this an impeachable offense or not? Right. And it almost becomes like, to the minds of some of those 44 who voted against, some of them may start to tremble a little bit and say, you know what, I can't really consider that anymore because the Senate's ruled on that. And now that it's been ruled, I have to remove that from equation. And now I have to examine, was this an impeachable offense or not, without examining the constitutionality of it. And that's kind of what's being brought up over here that you hit on earlier. So.
Yeah, I think so. Bryce Byerly says, to give Bruce the benefit of the doubt, I think he was trying to cast sleep on Congress. Yeah.
It was like one of those Harry Potter sleep spells. Yeah. Okay.
Snormondo! Okay, significantly, neither Belknap nor Blunt received the required 2/3 majority of the Senate and were acquitted, so their proceedings provide no binding precedent establishing the Senate's jurisdiction to convict former officials of impeachment. These cases cannot be read as foreclosing an argument that they never dealt with. This is critically important because the burden of proof applies to both jurisdictional and substantive elements. The substantive elements of a federal statute describe the evil Congress seeks to prevent. The jurisdictional element connects the law to one of Congress's enumerated powers, thus establishing legislative authority. Both kinds of elements must be proved to a jury beyond a reasonable doubt, and because that is so, both may play a real role in a criminal case. With impeachments, jurisdiction and guilt must be found by a two-thirds majority. Neither case established jurisdiction by the required two-thirds majority. These two instances present, at best, an example of hypothetical jurisdiction. This is a great argument. This is a great legal argument. And again, should have been read verbatim on the floor.
Yes.
Because that is a good point. How are you saying there's precedent if they were acquitted? They were acquitted. There is no like interim vote to say, well, we have jurisdiction. We think we have jurisdiction. We're going to hear the case. But if they're acquitted, then, well, maybe we didn't have jurisdiction.
Or you could say back to them, oh, really? It's a precedent? Did Congress back then pass a law that we can impeach former members of former federal officials? Was that a law they passed? Because I don't see a law anywhere here. I'm going through my statutes, my list of statutes. I don't see that they passed any law here. Why didn't they pass that law if everyone was so much on the same page?
Right.
Why is it that the Constitution still says what it says?
Because they don't have the luxury of a judicial opinion that you would get from a court ruling. So instead, the way Congress could do it is to pass a resolution that says we find a finding of law by Congress. Here's a joint resolution. Finding of law by the Senate says that in cases of former officials, we read the Constitution as to say X.
In 1879, they could have passed a law saying former officials can be impeached, but they didn't. Why not?
You know what's crazy? I guess they should have passed that law. Could they have done it prior to impeaching him? That would have been interesting.
That is a pretty cool question. I don't think they could have done it before the 20th because they wouldn't need him to sign off on it.
Yeah, they wouldn't have had their supermajority to do it. But
right.
Okay, so it is. Let's see. It is also worth noting that neither of those cases dealt with the president with his unique status in the Constitution and with the clear definitional limits that apply to him and not to others. Yes, that's true. They could have fleshed this out more. I don't know that they needed to, but that's a good point.
Although I'm sorry, I was thinking about what we were just discussing as far as passing a law. Would that be considered an amendment to the Constitution, or is that an interpretation of the Constitution, which is exclusively the domain? Or could Congress pass a law which serves to sort of interpret the Constitution as they see fit?
They could just pass Senate rules on it, right?
A Senate rule about the Constitution,
just in the Senate,
would thereby,
in the Senate impeachment rules, because they have a list of rules for the Senate impeachment process,
right?
And they could say that we recognize the jurisdiction over former officials, and then at that point, you could challenge the legality of that rule. You could take that to the Supreme Court, and you could say,
whether it's unconstitutional for them to amend the Constitution in that manner.
Right. That would be the argument, that this is an unconstitutional. The Constitution strictly limits them to this. They're trying to take this authority. Any president would have would have standing to bring that case, because any president would be subject to, or any former president, I guess, would be subject to the rule and a potential deprivation of their rights. So they could bring that. Trump could have brought it specifically, of course, as well in this case.
You would think. I'm a little surprised he didn't, honestly.
Yeah, I'm a little surprised he didn't try to do something straight to the Supreme Court as president. But maybe that was part of the legal strategy.
But here's the thing. If he would have brought it and they would have said, well, you're not president, we can't listen to you anymore. Well, that only goes to the point that, hey, I'm not president, I can't be impeached.
Yeah, I know. Would have been good.
Which, by the way, speaking of things they could have done, I think you sort of were implying this before, is when they got up there, they should have pointed at Mr. Leahy and said, that is not John Roberts. This man is not the Chief Justice here. Boom, end of story.
Schoen did that. He did that. But again, all this happened so far into their presentation that it lost all of its effectiveness.
Yeah, everyone was asleep.
It should have been one of the first things. Like, you can pick any starting point, any one of these arguments. You can come out and you can say, honored members of the Senate. Where's John Roberts?
Yeah.
Where's John Roberts?
Or you know how you could do it even better?
Hey, we got a
The same
president over
thing.
here. Where's John Roberts?
Yeah, exactly. The same thing. He could have like accidentally referred to Leahy as Chief Justice Roberts with the permission of Chief Justice Roberts. Oh, excuse me. The same way, remember Corey
Yeah.
Lewandowski when he was testifying, he referred to Swalwell as President Swalwell. So
Yeah.
so he could have like accidentally referred to me saying, with the permission of Chief Justice Roberts. Oh, I'm sorry, Mr. Leahy. And thereby make the point that like you all know he's not president. Everyone here knows he's not president, and this is illegal.
Socialism is for Fig says, okay, I'm giving $20 more to tell your friend to stop the ASMR into the mic with his birthing technique of heavy breathing. Oh.
Am I really doing that? Am I doing like the Lamaze thing here?
It's when you turn your head to the left and kind of look down.
I'm gonna go like this to read?
The mic picks up because it's right
everything.
There. Yeah.
Okay.
Yeah.
All right. So I'll do this. I'm gonna hold it away from me. And seriously, if it's an issue, then
I'll let you know. I'll let you know.
Yeah, let me know. I don't want people to be sitting there thinking I'm like some heavy breather. I'm like after the show, I'll be calling them. Or...
Just put cocaine on the microphone and shove it in your nose. It'll be fine. Andrew War Snowboard says, off topic, but should COVID positive patients be allowed in public? Yes. I mean, I don't see the legal basis for restricting them personally. I never have.
Besides, are you COVID positive? Are you? You don't know.
Yeah. That's we've never held a deprivation of liberty due to infectious disease at the federal level. The closest we ever had was typhoid, which was very limited in, I think, New York only. And that's about it. Like, we don't do that because you don't have a duty to not transmit an infectious disease to someone else, especially one that's transmitted by air. But that's a different discussion for a different day. More recent impeachment proceedings. In the past, Congress has acknowledged and exercised its duty to not impeach when an official is no longer in office. In the case involving the impeachment of President Richard Nixon, Congress decided not to impeach because he resigned. As a practical matter, the resignation of an official about to be impeached generally puts an end to impeachment proceedings because the primary objective, removal from office, has been accomplished. In May 1974, the House Judiciary Committee began formal impeachment proceedings or hearings against President Nixon in regard to the Watergate scandal. And on July 27, 1974, the House Judiciary Committee approved 3 articles of impeachment and reported them to the full House for consideration. Knowing that he was about to be impeached in the House and convicted in the Senate, Nixon resigned on August 8, 1974. The House officially ended the impeachment process against him on August 20th, 1974 by accepting the committee's report but deciding not to further advance impeachment proceedings. As Professor Babbitt explained, why didn't they go ahead and impeach him when he resigned? The answer is they didn't believe they had the authority to impeach someone who could not be removed, someone who is no longer, as the constitutional text requires, a civil officer of the United States. A memo from the Office of Legal Counsel at the time reached a very similar conclusion. Quote, as a practical matter, if the president should resign, this would probably result in termination of impeachment proceedings. All right, we've got Bad Vibes says, for Joe, say, he, it's me again, Margaret. That's for you. You're supposed to say, he, it's me again, Margaret. I don't know what that is.
It's me again, Margaret.
I don't know what that is. I don't
How much money did I just make you? Was that like $5? That was
that was 20 bucks.
All right. For that, for $20, it's me, Margaret. Is that me again?
Yeah.
It's me again, Margaret. All right. Does my voice sound like that? Because I've heard that I sound like some people say I sound like that guy from Ice Age, Ray Romano, whatever. What's his name?
Oh, Ray Romano. Yeah. Okay.
Some people say I've gotten that. Some people have said that they hear Al Michaels, which those two don't sound anything alike at all to me, but I've heard that.
It's Ray Stevens.
So, I sound like Ray Stevens?
Okay, that's what they're saying.
No, that's not Ray Stevens. The guy who plays from that show, Everybody Loves Raymond.
Yeah, Ray Romano. I hear the Ray Romano that's coming through, but is that from that show? I don't know.
No, that's not he. It's me again, Margaret. I mean, I don't know. I'm wondering if that's a reference to some other famous voice.
Ray Stevens, The Streak. It must be a song, maybe.
Okay.
Who knows? I don't know. I have no idea. Okay. Real quick, I have a question for you. Do you think there's a distinction between resigning and your office term expiring?
Yes.
Me too.
'Cause, 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 '
And
The
I'm
reason
annoyed
is
that they
because
don't hit it.
right. And the reason for that is because anyone could resign in order to save themselves the embarrassment. And here's the interesting thing. The expiration seems like it that should be that much more of a termination because it's not someone who's just trying to avoid the scrutiny of their wrongdoing, but someone who just happens to be out of office. Now it becomes a moot point. So we don't want to reward someone for trying to avoid that scrutiny. And when it came to Nixon, he clearly was trying to avoid that scrutiny and that embarrassment. So if you're not going to do it to Nixon, who was running away from that responsibility and that accountability for what he did by Watergate, all the more so when someone's term expires, there's even less reason to say that he's impeachable.
Right. That
So,
I agree. I think that is a huge miss on their part, saying even if we accept that we can impeach former officials who have resigned, Donald
like
Trump did.
Belknap, right? Belknap
Yeah,
ran away.
Belknap and Blunt, both of them, and Nixon.
Yeah.
Donald Trump did not resign. His term expired. They asked him to resign. They asked him to run away. They begged him to run away. He chose to stay the course, confident that he had done nothing wrong, nothing worthy of resignation. He was clearly not hiding from this impeachment. He was not hiding from the enforcement arm of Congress, because this is all political theater, and there is no teeth here. They waited to impeach him. It's their fault for taking too long. In civil court, we would employ the doctrine of latches
Nice.
or mootness, and this would be done.
Yeah, this is mootness. That's
Yeah.
what it is.
They should have just thrown latches and mootness back in their face over and over.
Beautiful. I love it.
Okay, so state courts have rejected claims similar to those made by the House managers in similar late impeachment matters. While the Supreme Court has not yet addressed the question of a late impeachment, some state courts have. In State versus Hill, Supreme Court of Nebraska dealt with the exact same substantive question facing the Senate now on almost identical constitutional language. They addressed head-on and dismissed the same claims that the House managers now make. First, they started with the plain meaning of the word officer at issue. Quote, it is urged by counsel for the managers that ex-officers are liable to impeachment for official misdemeanors committed while in office. That jurisdiction attaches immediately upon the commission of an impeachable offense, and that the expiration of the official term does not deprive the legislature of the power to impeach or the court to try. It cannot be said that there is any provision of the Constitution which expressly confers the authority to impeach a person after he is out of office. While Section 5, already quoted, designates the persons who may be impeached as all civil officers of the state, this language is unambiguous. It means existing officers, persons in office at the time they are impeached. Ex-officials are not civil officers within the meaning of the Constitution. Jurisdiction to impeach attaches at the time the offense is committed and continues during the time the offender remains in office, but no longer. Then the court proceeds to address the question of disqualification as a separate remedial punishment. The necessary implication of the provision in Section 14, Article 3 of the Constitution that judgment in cases of impeachment shall not extend further than the removal of office and disqualification to hold and enjoy any office of honor, profit, or trust in this state is that the offending party, oh my God, this is a long quote. The offending party must be in office at the time the impeachment proceedings are commenced. In case of impeachment, either one of two judgments can be pronounced, namely removal from office or removal and disqualification to hold office. It is obviously that there can be no judgment of removal when the party was not an officer when impeached. It is claimed by counsel for the managers, as we understand their argument, that a judgment of disqualification can be entered without a judgment of removal. All will concede that disqualification to hold office is a punishment much greater than removal, so that if the construction contended for by counsel is the true one, then in case the person impeached is out of office, he is liable to a more severe penalty than might have been inflicted upon him had he been impeached before he went out of office. We cannot believe that the members of the convention who framed the Constitution so intended. Judge Story, in discussing the question whether a person can be impeached after he has ceased to hold office at Section 803, says, as it is declared in one clause of the Constitution that judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office of honor, trust, or profit under the United States, and in another clause that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes or misdemeanors, it would seem to follow that the Senate on the conviction were bound in all cases to enter a judgment of removal from office, though it has a discretion as to inflicting the punishment of disqualification. If, then, there must be a judgment of removal from office, it would seem to follow that the Constitution contemplated that the party was still in office at the time of impeachment. If he was not, his offense was still liable to be tried and punished in the ordinary tribunals of justice, and it might be argued with some force that it would be a vain exercise of authority to try a delinquent for an impeachable offense when the most important object for which the remedy was given was no longer necessary or attainable, and although a judgment of disqualification might still be pronounced, the language of the Constitution may create some doubt whether it can be pronounced without being coupled with removal from office. So again, that's a fantastic quote, and a solid analysis from a Nebraska judge from who knows when. I don't know.
I'm sure they have a date on that, right?
Yeah, I'm sure in the citation, 1893. No, they're quoting a case from 1893. Good Lord. Let's see. State versus Hill. Yeah, 1893. Jeez.
Yeah.
So again, approximately close in time to the actual, much closer in time to the previous stuff. So that's a good decision. It's state court, but there is no Supreme Court precedent, so you go with what you got.
Yep.
The most recent state court opinion on late impeachments is Smith versus Brantley, a Florida case from 1891 that also declared late impeachment unacceptable. Florida Supreme Court held that officers are officers. Ex-officers who could not be suspended or removed from office are not. The court was thus making the linguistic argument that officer meant sitting officer and the functional argument that the primary and dominant purpose of impeachment in Florida is removal of an office holder from office. Once an officer has resigned, this purpose is fulfilled, the court said, and the mere possibility of disqualification from future office does not change the fact that the main purpose of the process has been achieved. The court considered Blunt, Belknap, and Ferguson, but argued that in each case the resignation did not occur until impeachment proceedings had begun. So there you go.
But here you could distinguish and say that the impeachment proceedings here did begin before he left office. So since they began before, so that's a distinction. If you want to look at it as a lawyer from the House Democrat side,
yeah.
So you can say they had started while he was still in office, and therefore we can continue doing it even after he's left office. So you can definitely distinguish from this Florida Supreme Court case if you're on their side.
I think it's important to make them make that distinction because then you get to ask, but you didn't serve the papers on the Senate until after he was out of office. So was he actually impeached? Impeachment proceedings had not actually begun because the House.
But this case here says if it's begun, you don't have to necessarily have impeachment. As long as you began it while he was still in office, in that case, you could theoretically be allowed to continue it, even if you haven't delivered the papers or decided and ruled in favor of impeachment. Once the proceeding is begun and he's in office, you can continue going forward. So in that sense,
but as
the Democrats can use this to support their case if you think about it.
But as a question. Let's say the Democrat or whoever, the House drafts articles of impeachment and then never delivers them. Did impeachment begin?
Yeah, impeachment begins as soon as they raise it on the floor of the House.
So even though they never deliver them and there is no impeachment trial ever,
according to this Florida case, which distinguishes between itself and this Florida Supreme Court seems to believe that Blunt, Belknap, and Ferguson, in their case, the resignation did not occur until impeachment proceedings had begun, and therefore they could continue since they had begun. Begun is, I assume, introduced on the floor. That's what I would assume means begun, not that they've actually ruled for impeachment, and then we have to have a follow trial.
Yeah, let's see. Because that's when they just introduce the articles. That's not even when they pass them. Because both of these guys did resign before the actual passage of the articles. So but I think
but they were allowed to proceed. I don't think this really helps Trump. I think that this could be turned and looked at from the other perspective and provide equal support. So I understand what they're saying. I understand what they're saying, and they're trying, I think it can be taken either. To be fair, I'm just trying to play devil's advocate as far as how do I make a legal interpretation?
It's our job.
Right. So how to make a legal interpretation of this, and I'll tell you that I could easily interpret this Florida case as supporting impeachment, because I would say that the Florida courts certainly seem to believe that once an impeachment process had begun, it's allowed to continue even after there's resignation. That's what the Florida court interpreted about Blunt and Belknap, Ferguson, and so too over here, since it started before January 20th, we are allowed to proceed with it. And the Florida court would agree with us. We're allowed to proceed with that. We're just like Blunt and just like Belknap, and we can proceed even if they hadn't ruled on impeachment at that point. Once it's introduced on the floor, it seems like it begins when they introduce the bill on the floor even before there's a vote in favor of impeachment. That seems like the start of the process.
Yeah.
So
Jason McConnell says they never went after Richard because it was known that Pat Nixon was, in fact, an actual Kraken. Yes, YouTube bans that word now. He had to hyphenate Kraken. Cringelord says, why the hell is the Senate having a vote on constitutionality and not the Supreme Court? Why didn't Trump sue the United States for violation of due process as a citizen? We talked about this a little bit yesterday. I have a theory that a president may not actually be able to sue over his impeachment until he is in fact removed from office.
So I mentioned yesterday, I sort of teased tonight's show by mentioning that I have a theory about Trump in his final days.
Yeah.
And what we saw there from him was very un-Trumpian compared to what we'd seen from 4 years. Over the last 2 weeks, his conduct with respect to the pardons that he gave and did not give, both the ones he gave were weird, and the ones he didn't pardon Assange or Snowden, and everyone expected that was going to happen. And I suspect, if you ask me, my gut is that they came to him and they said, look, you know you're not going to get impeached. That's not going to happen. But do you want us to spend the next, you know, you're going to live out your life. I think that certain demands were made of him. I think that he gives certain pardons, that he not pardon certain people who are politically distasteful to certain powerful people who don't want Snowden and Assange pardoned.
That was a rumor news story that
I think he was blackmailed.
Yeah, that McConnell went to him and said, if you pardon Assange, you're impeached. That you lose Republican support, and we will impeach you.
And even if it's not that, there's so many ways they can threaten him. They could threaten. I think they could have threatened him not to open up social media. They say, if you do, look, you can go off into the sunset, go run your businesses that you have, keep doing it, and we'll let you go. We'll have this impeachment proceeding. You'll win, and then you move on. And if you don't go along with the program, since we are going to be in power, we're going to chase after your kids, and we're going to try and have them named in all these different criminal suits.
Yeah.
And they're going to spend the rest of their lives, Ivanka and Donald and even Barron, they're all going to be fighting off these litigations for the next 25 years unless you do what we want from you. And then he basically is like, you know what? Fine. What do I care about who gets pardoned, who doesn't? And I don't have to open up a social media company, or I don't know if that was part of the whole deal or not. But the point is, there's a lot of ways they could leverage him and say, you know, you might be 78 or 74, whatever it is, you're going to be 78 in 4 years. You might not be worrying about your future and what you're going to do. You can sit and retire, but you are worried about your kids. And they've been very tied up in here. And even if there's complete garbage, empty claims, we can make their lives hell for the next 10 years unless you do what we want.
And they really can. I mean, they can cost them enough to actually impact even the financial assets of someone who's a billionaire. I mean, the state has the power to make your life that miserable.
Yeah.
All right. Yeah, no, I agree with that. I think that would be 0% surprised if that happened. That's how that's how federal prosecutions operate. Like, that's not a secret. They did it.
Chuck Schumer said we have 6 ways to Sunday to get at you.
Yeah.
And that's basically, and they could have just brought this up during the last 2 weeks. They have 6 ways Sundays to get at you and your children. Do you really want them fighting with this? Mm-hmm. You really want Jared to be like facing criminal trial for the rest of his life?
Yeah.
Or you want to let them all live their lives in happiness and everyone just goes and does their thing and let us take our power and you step down and do what we want during the last couple of weeks?
It would also explain why he didn't pardon his family. Because in my opinion, he absolutely should have.
Right. But he could have.
He definitely could have. And so then but he was told not to by White House counsel, not to pardon himself and not to pardon his family. It's like, well, that's bad legal advice, but it might have been okay personal advice if they said, if you pardon us, if you pardon these people, we'll impeach you. We'll argue that the pardons are null and we'll make their life a hell. And maybe they win the argument that the pardon is still valid, but maybe they don't. And you spend millions of dollars fighting for that.
Although between you and me, maybe he issued them parties and no one's seen it yet.
You are not alone in that thought. Michael Cohen, former counsel of President Trump, said the pocket pardon is very possibly a thing where he created the pardons, drafted and signed them, did not actually reveal them and won't until there's a prosecution.
And found some way to date them, to document that it was dated before January 20th. And this way he puts them in a vault somewhere. If anyone ever comes after them, they have these pardons. And until that happens, there's no reason to raise a whole scandal that he's looking out to protect his kids.
Yeah. All right. Back to the document. Congress's power to impose penalties upon conviction of impeachment is limited to removal and, not or, disqualification. Constitution grants Congress only the power to remove a person's right to run for office when it is part of the process of removal from office. Article 2, Section 4 of the Constitution states that the only purpose of an impeachment is whether the president, vice president, and all civil officers of the United States shall be removed from office. The only purpose of impeachment is to remove the president, vice president, and civil officers from office. When a president is no longer in office, the objective of an impeachment ceases. The impeachment trial is being pursued solely to preclude Mr. Trump, a private citizen, from holding any future office. However, the Constitution does not provide for the impeachment of a private citizen who is not in office. Further, the Constitution only grants the Senate the additional power to remove a person's right to run for office as part of the process of removal from office. When a person ceases to hold an office, he immediately becomes a private citizen, impervious to removal, and therefore to impeachment and trial by the Senate. And I think this is important. I don't know that they argue this, but this is an important distinction because once he is no longer the president, he loses his theoretical immunity from, like, he loses his sovereign immunity from civil lawsuits, and he loses his theoretical immunity via the pardon power or clemency against his own criminal convictions. That's why the impeachment process exists, is to first strip them of the power to insulate themselves from these processes, and to then allow, if there is a subsequent claim, to go after them in either criminal or civil court. I mean, that's
why you need impeachment in the Constitution.
Right.
Otherwise, you wouldn't need it.
Exactly, because you could, and we've heard this for 4 years. They're not even sure if they could indict a sitting president.
Right.
Like so you have to remove them first. If he removes himself from office by either resignation or from the expiration of his term, he no longer has the power to avoid that indictment. And so, again, the whole purpose of the impeachment is mooted at that point. As Professor Harold Krent has noted, although the impeachment clause in Article 1 states that the penalty for impeachment shall not extend beyond removal and disqualification from office, that clause reads as a limit on what type of punishment can be meted rather than addressing when. The framers presumably were signaling the change from the British practice under which additional penalties were possible. There is no language in the Constitution suggesting that the impeachment authority is continuous. This idea was perhaps best expressed by Supreme Court Justice Joseph Story in his influential 3-volume treatise Commentaries on the Constitution. Section 801. As it is declared in one clause of the Constitution that judgment in cases of impeachment shall not extend further than a removal from office and disqualification to hold any office of honor, trust, or profit under the United States, and in another clause that, quote, the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes or misdemeanors, it would seem to follow that the Senate, on the conviction, were bound in all cases to enter a judgment of removal from office, though it has a discretion as to inflicting the punishment of disqualification. If, then, there must be a judgment of removal from office, it would seem to follow that the Constitution contemplated that the party was still in office at the time of the impeachment. If he was not, his offense was still liable to be tried and punished in the ordinary tribunals of justice. They mentioned this section earlier, and it might be argued with some force that it would be a vain exercise of authority to try a delinquent for an impeachable offense, when the most important object for which the remedy was given was no longer necessary or attainable, and although a judgment of disqualification might still be pronounced, the language of the Constitution may create some doubt whether it can be pronounced without being coupled with a removal from office. Now, I think they missed an opportunity here as well. Schoen briefly talks about their 14th Amendment claim that's in the Articles of Impeachment, that if a official is party to an insurrection, then they are disqualified under the 14th Amendment from holding office in the future. Right? Like,
okay.
Are you not agreeing, or are you not sure, or what?
I'm digesting.
Here, I'll read it real quick. I've got Amendment 14 here. Okay. Here we go. Representatives shall be apportioned among the, but when the right to vote in an election for the blah, blah, blah. Let's see. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So the 14th Amendment provides a remedy for convictions upon insurrection or rebellion already.
Okay.
So
in other words, you don't need to impeach him.
Again,
you just find them guilty of, if you find them guilty of incitement, in that case, you don't need to impeach them.
Right. And they included that argument in their article of impeachment, the 14th Amendment. But I think the 14th Amendment weighs against impeachment in this case because it specifically accounts for an alternative remedy. You can preclude him from ever entering office if he's actually guilty of this incitement. Just try him. Just try him for it.
The thing is this: what your argument here underscores that and why it is that I've been saying that they're dancing on the Constitution and burning it, because they're basically treating impeachment as if it's just some run-of-the-mill remedy that we can invoke whenever it is that the mood strikes us. And that's what you see from how many times they brought it up, as opposed to recognizing the specialness of this remedy, that it's a unique situation and it's a unique, important remedy that should be recognized and sort of cherished as an important part, that when necessary, when you really look, it's sort of like the nuclear option. That's what impeachment is. It's a nuclear option. And they're they're so reactionary. The left is so reactionary that any time somebody steps on one of their toes, it's like, well, I gotta find that nuclear button. Where's that nuclear button? Get me the codes. I'm launching the missiles now. Impeachment is not something you just throw out there every 10 seconds. Oh, we're upset at this, we're upset about that. You're raising the point here. You don't need impeachment. If you have the 14th Amendment, which says that anyone who's sworn to office incites insurrection, then even if he's completely innocent of it, just find him guilty of incitement, and boom. This whole remedy, this relief you're seeking, that he never holds office again, is going to be effective against him under the 14th Amendment.
Right. It already exists. The House manager's failure to grasp this concept is evident from their misplaced reliance on this language to try and create a workaround of a problem of their own making. Mr. Trump was no longer president at the time the House filed the articles of impeachment in the Senate. Instead, their argument further demonstrates the point that Mr. Trump could not be removed from office because his term ended, the condition precedent to any further penalty. As Professor Alan Dershowitz explained, the Constitution is clear. The president, ... shall be removed from office on impeachment, ... and conviction, not by the expiration of his term before the impeachment process is complete. It also mandates that judgment in cases of impeachment shall not extend further than to the removal and disqualification, not or disqualification. Other scholars have forcefully rejected the failed interpretation the House managers try to advance in an effort to salvage this doomed impeachment by spelling out the unstated assumptions inherent in their position. By this logic, a president could be disqualified from holding office without being removed, an obvious absurdity. This argument asserts that because the Senate could, by a simple majority, disqualify a person impeached and convicted under Article 2, it would thwart the operation of Article 1, Clause 7's list of permissible punishments to let the convicted former officer go free, where it otherwise an officer could avoid removal and disqualification by simply resigning. This circular argument assumes the truth of the proposition that a person no longer in office can be impeached in the first place, and then infers from this assumption that such a power should not be frustrated. It is not compatible with Article 2, which provides the sole constitutional grounds for trial in the Senate, on the basis of which impeachment penalties can be imposed, the commission of bribery, treason, or other high crimes and misdemeanors by a civil officer leading to his removal. It relies instead on a tortured inference from Article 1, whose text says nothing about who can be impeached or on what grounds, in an effort to salvage the penalty or of disqualification where an official has been impeached while in office but has resigned. Advocates for this view would have the Senate convict a person no longer in office, inventing a new basis for conviction beyond that provided in Article 2. You know why I love secondary sources? Because they get to use all the language that you can't use in court. They get to write with some flair, and you can just quote them. Because this one's good, right? That's some good writing.
By the way, there was an argument that Mr. Southern Baptist raised today, which I thought was an interesting argument that you and I probably should flesh out.
Sure.
And that is, let's assume, according to this argument, that you cannot impeach someone if it's past January 20th, and he's left office now. What would have happened if, let's say, on January 19th, Donald Trump did something like he called up someone in front, he said, oh, here, Putin, here are the codes to our nuclear, to our nuclear facilities. He
Right.
did something, and you're going to give me $1 billion, and I'm going to give you our nuclear codes. And
Right.
everyone knew about it. They did it in public. Okay, they took $1 billion from Putin for giving the nuclear codes. Now,
Right.
every one of us would say, of course, he should be impeached. But as a feasible thing, it's impossible to impeach him that fast. So, would you still say that no, we can't impeach him because it's too late?
Ye- What date does he
Because
do this?
that's
On his last day of office, are we saying?
no,
Like,
the second to last day. In other words, it's
yeah.
definitely not feasible to do. The morning of January 20th, he goes out there and he says, and he basically takes $10 billion for the nuclear codes that he gives to some foreign agency. Obviously, everyone else believes that that's a clearly impeachable offense. Anyone who would do it, should go to jail. But the question is, should he be impeachable or not to make sure he never holds office? And the question is, will you still stand strong? Will you still say, you know what? No, we can't impeach him. He's out of office. Go convict him. You want to convict him? We can convict him.
So the hard part with this question specifically is whether or not he can be convicted for that. So as head of state, does the president have the authority to hand over nuclear codes to another head of state in his sole organ authority, right? Sole organ of foreign relations, and his ability to enter into an executive agreement, even absent a treaty? He might actually have the authority to do that.
But you're dancing around my question, Nick. My point is, if he does something that's clearly impeachable, he takes a bribe and he basically does something to
Okay,
really
so he
harm
does
the
something
country.
actually like certifiably illegal that harms the country.
Certifiably illegal that anyone would say for sure he should be impeached for this.
Yes, I hold ground. I say you can't impeach him. Take him to criminal court immediately.
And it jeopardizes the security of the United States of America. Still not impeachable. You can take him to trial. You can arrest him. In theory, give capital punishment for it, but not impeachment. And I think I would hold strong there too.
Yeah.
I would say, why do you have to impeach him? You don't have to impeach him. He's not in office. You don't need to do it.
Look, if someone gives the nuclear codes to a potential enemy of the state, I don't want them impeached. I want them removed from life.
Right.
Like,
yes.
I want them either, put in a brig on a ship, like a really uncomfortable old ship that rocks a lot, so they're gonna be miserable for the rest of their life. I want
a really angry man who finds them attractive.
Right.
Yeah, you want them to be punished.
I want them in Gitmo. Like, I want them forced to read the Quran with their cellmates or whatever. And then, or I want capital punishment at that point. I don't care if they never hold, I don't want them to hold off. That guy's not going to hold office ever again. I mean, I'm not worried about that remedy at that point.
Right.
So no, I hold fast. In fact, I think his chances are getting better by the day, but I still doubt the ability of Trump to competently run in 2024. Like, I don't think this prevention of running again was actually, I think this impeachment trial might actually bolster his ability to run in 2024 in the long run. I think if they
the first one made him more popular.
I think if they let Trump just sort of expire with January 6th in the background and never said a word really about it in an official capacity.
Until he runs, and you're like, this is what this animal did. It's much more powerful.
We all tried to heal as a nation. We moved on. We let it go. But this is the horror that this person inflicted upon us back in 2021, and we cannot tolerate that again. And you do that, and I think you hamstring any ability he has to run in the future much more effectively than this.
Agreed.
So again, and if I think that about Trump, who I don't think incited the insurrection, I just think that the events of January 6th outside of his control made him politically toxic. I certainly think that about anybody who does something so brazen and overt.
Yeah.
So that's my opinion.
You're right. It's like almost like the silent looming element to what he is. By making a big stink about it now, you're sort of burning your dilithium crystals. You're like basically you're jettisoning the dilithium crystals too early.
Yeah.
You understand that reference?
Yeah, that's a Star Trek. That's a Star Trek reference.
Yeah. So you're sort of jettisoning it now in 2021 instead of actually using it when it's most effective in 2024.
Right. And again, I think every public appearance of this reinforces and reasserts his support amongst his base. The more and more they look at it and they go, you know what? On January 6th, I thought the riots were really bad. Now I kind of look at it and I go, I don't think Trump's responsible for that. It wasn't that bad. It could have been a lot worse. I mean, they could have, and if you really think about it, these guys could have walked in there with guns. They could have walked in. This is America. They could have walked in there with rifles. Some could have walked in with automatic rifles and gunned down everybody that they saw. There would have been no stopping them. Capitol Police could have done nothing. The moment they were in that building, if someone pulled out even an AR-15 and started popping Capitol Police officers as they walked down the hall, they could have easily gotten into the congressional room and they could have tagged every single one of them. There were plenty of people to soak up bullets in that mob, and with a real organized effort to cause violence, they could have done incalculable damage, and no one did. And I think the more people look at that and they go, wait a minute, no one brought a grenade or a Molotov cocktail and lit someone on fire. Like if this were...
Or a knife. Or even a knife.
Yeah, let's play this out and we're in Colombia or Bolivia or Ecuador.
Yeah.
And let's see how many skins of politicians aren't hanging from the flagpoles the next day. Literally skins with no bones flapping in the wind. Because Central America is brutal. And Central and South America.
Hey, it was much less than what happened in Capitol Hill, Washington. The whole Chaz zone. I mean, there was much more violence going on. There was much more craziness going on there as far as like people like really looking to hurt others than what you saw in the Capitol. The difference is the site obviously is far more significant in the Capitol. But I mean, as far as the level of violence that we saw, it's really it's a joke compared to the countless riots that we saw over the summer.
Yeah, that's what I'm getting at. I'm not trying to downplay what happened at the Capitol. I still think it was a terrible idea, and it did nothing but harm to Trump and the Republicans in the long run, or in the short run, and probably in the long run. What I'm saying is, like when we consider the possibility of what could have happened, and as people distance themselves from that event, guys, we have people downplaying what happened at 9/11 because we're 19 years away or 20 years away from it now, almost. We have people downplaying that. This thing is going to be forgotten largely within a year or 2 years. And had they let it loom and fester rather than talking about it incessantly, I think they could have preserved the power of it. But that's me. That's me. Okay, let's go. The Constitution. Wait, Amateur Ant says Trump's first mistake was listening to the Republicans to fill his cabinet, then not firing everyone that was, dumbass supporter, at least in the White House, then appoint judges the Republicans put in front of his face and trust them. Smack my damn head. IWD says, when they stormed the Capitol building equivalent in Argentina in 2001, they set fire to 25 city blocks on their way to the building itself, and congressmen asked to have last rites read to them just in case. Yeah, again, it's important to remember, like, how much violence didn't occur and how much worse it could have been. I mean, again, the way they talk about it, armed militias stormed the Capitol. I'm like, but they didn't shoot anybody.
They weren't armed. Were they armed even?
There were some guns there. None were drawn. The only gunfire that I've heard of happening was the Capitol officer who shot Ashley Babbitt, who was unarmed. So the concept.
And look. And no one should take from this anything other than that Nick and I both agree this was a terrible, terrible tragedy. It shouldn't have happened.
No.
And it's really unfortunate, and we really feel that it's and aside from that, politically for the right, it was terrible. But that's even secondary to the destruction of life that we saw, which was really awful. And it was predictable that once they went in there, that people were going to get very seriously hurt. And that's the reason why this never should have happened the way it did.
Right. Yeah. And
that being said, this is not the first incident of the kind that we saw. If anything, in 2020 into 2021, we saw dozens, if not hundreds, similar incidents in much smaller settings. And yeah, the level of violence, there almost was a certain restraint that was displayed compared to the level of violence that we saw over the summer. And anyone has to be blind to ignore that.
Right. Yeah, exactly. We had an entire year of violence. It's amazing. The Constitution does not provide for an impeachment of someone who is not in office as a means to an end result in only disqualification, and for good reason. As Alexander Hamilton wrote, nothing is more common than for a free people in times of heat and violence to gratify momentary passions by letting into the government principles and precedents which afterwards prove fatal to themselves. Of this kind is the doctrine of disqualification, disenfranchisement, and banishment by acts of the legislature. The dangerous consequences of this power are manifest. If the legislature can disenfranchise any number of citizens at pleasure by general descriptions, it may soon confine all the votes to a small number of partisans and establish an aristocracy or an oligarchy. If it may banish at discretion all those whom particular circumstances render obnoxious, without hearing or trial, no man can be safe, nor know when he may be the innocent victim of a prevailing faction. The name of liberty applied to such a government would be a mockery of common sense. The House managers put a lot of misplaced importance on the fact that Article 1, Section 7 contains a clause reminding Congress of its own limitations, namely that after a conviction and removal, the only other penalty Congress can impose is disqualification. Quote, judgment in cases of impeachment shall not extend further than to removal from office and to disqualification to hold and enjoy any office of honor. Does not mean that disqualification is a separate or alternative form of punishment entirely. Disqualification from future office is simply an additional discretionary penalty that the Senate may impose once it has determined the original purpose of the impeachment. Removal is proper. Disqualification, however, is not the purpose of an impeachment proceeding and is not available simply to disqualify a former public officer from future office holding. Now, what's interesting here is, I don't know that they cite to any cases, but I believe there are Supreme Court cases that specifically discuss this, that discuss the removal power as a separate but subsequent power, not a separate co-equal power.
Yeah,
I read them.
You're talking about the future disqualification being a separate but unequal. It's almost like a subsequent effect of it.
Yeah, and
but not that it's a remedy unto itself.
Right, and the Supreme Court cases make that clear. Only after a vote for removal can you have a vote for disqualification, which is why it's a simple majority as opposed to a two-thirds majority, is that you've presumably already passed the hurdle of the two-thirds majority, and now we're just going to determine if this person is bad enough to merit no
penalty
further
phase.
action.
To merit the penalty phase of, do we give treble damages, so to speak?
Right.
Or just,
But that is not all. House managers are not content to argue that an officer who is impeached while in office can then be tried after they leave office. The House managers dig in further and claim that a person can be impeached at any time after they leave office. The absence of a statute of limitations suggests that process is confined to present office holders. A federal cause of action brought at any distance of time would be utterly repugnant to the genius of our laws. In addition, at any given moment in time, quote, the majority party could threaten to impeach former office holder of the minority party unless support is forthcoming on a particular appropriations or other bill. In other words, the ongoing threat of impeachment might distort lawmaking and, as a functional matter, might interfere with the balance of powers otherwise prescribed in the Constitution. Okay, hypothetical for you, Joe. You're making this argument right now, that under their interpretation, they can impeach anybody who's already been in office. Mm-hmm. Who do you pick as a potential target to, like...
Oh, Obama.
Okay, Obama?
That 5 years from now, that when the Republicans have a majority and they want to fight over eliminating, we say we want to eliminate Obamacare altogether, or we're going to impeach Obama. Pick one.
Who else do you pick?
Are you going to?
Like, give me a top three. Any top three.
Kennedy.
Okay. And then one more. Like Hillary.
Hillary.
Hillary's a good one.
Hillary. Yeah, Hillary's an easy one.
Do you pick Eric Holder?
No one cares about Eric Holder.
Bruce Castor cares about Eric Holder.
Really?
When making this point, the one person he brings up is Eric Holder.
Really?
I'm not even joking. I'm like, Eric Holder? Why are you talking about Eric Holder? No one's talking about Eric Holder. I haven't heard his name in years.
That's who he came up with.
That's who.
To me, I think the obvious choice is are Obama and Hillary, and probably I would reach. You might go to Bernie, but like Bernie's still there, so you don't want to mention him, and because you're sort of implying that he'll be dead in the next couple of years. But yeah, I would you picked the most popular Democrat of all time, and that's Kennedy.
Yeah. Yeah, and
I
again,
mean, truth is, Obama's probably more popular, but he's the sexy Democrat that you want to sort of take down and say, oh, look, we can bring up the Bay
well,
of
yeah,
Pigs and
you
say
pick up
that he's.
Obama. You pick Obama because he's alive. You pick Kennedy
Hmm.
because he's dead. And
Hmm.
those two things are, and his term didn't end
and
by
and
expiration.
you picked the most inspirational woman of all time, the most accomplished woman of all time, who
Hillary
has so
Clinton.
much on her resume. I mean, she's the deepest resume in the world, who obviously earned her stripes and made it in New York, the toughest place in the world for anyone to make it. Yeah, the legendary Hillary Clinton.
Yeah, I think that's who you threaten too. I mean, people like
Eric
that.
Holder. That the truth is, Eric Holder's probably four. He's number four on the list right there, right? I mean,
Yeah, it's true. I limited you to 3. I knew you were gonna get around to Eric Holder. Oh,
did he really? He made this argument, and
yes.
Mr. Holder, you better watch out.
He said
Because
the Republicans very well could. I mean, they could take power back in 2 years. And then, they could in theory impeach anybody like maybe Eric Holder. And like everybody's like
who?
why?
Who?
Why would anybody? No one cares about Eric Holder. He's not running for office. He's not all that popular. And then he goes on. He's like, well, I bring up Eric Holder because he had a really phenomenal career, and I think he's the kind of person that might be able to
Oh,
whatever.
no. I want to change it. Who's the
Okay,
one
yeah.
who they just had the funeral? Who's the one who they just had the funeral for?
Ginsburg.
Today. No. First of all, Ginsburg, that actually is not a bad call either.
Yeah,
We can impeach. Let's impeach Ginsburg, but that's actually better than Hillary. I like impeaching RBG even better, because
yeah,
it's like almost we're gonna spit on her legacy, like
yeah.
the
It'd be
Saint Ruth
pure
Bader.
spite.
Yeah, exactly. But who's the guy? They just had the funeral for today. What was it?
He had a
It was
funeral today.
or 2 days ago. James. Wait, John.
I have no idea. I was only following this today.
Oh my God. John Lewis. Am I having? I'm having a brain fart right now.
So quasi quirky creation says it's not what he said, and you know it. No, it is what he said. He also said because of Fast and Furious as the reason for the impeachment, but he said he picked Holder because he had a phenomenal career, and that's why. So he might have the ability to run for office, and then they could disqualify him. That's what he said. I didn't misrepresent his statements. The reality is Eric Holder is a terrible choice for this argument because no one on earth right now is thinking about Eric Holder. He doesn't enter into anyone's mind other than Bruce Castor. That's the only person in that room. When he's making that argument, I guarantee you, he's going, they could impeach anybody. And everybody in that room is running through a list. Their Rolodex is flipping through in their minds. And they're going, okay, Obama. Man, they could go after Obama.
Obama's top of the list. Anyone how you don't come up with Obama first is just astonishing.
You can maybe go to Jimmy Carter because he's still alive and like people kind of like him. He talks a lot. You're running through these people in your minds. Nobody's Rolodex has Eric Holder in their mind on this question. That's why it's a bad argument. It's not that it's not. I mean, yes, Eric Holder could be impeached over Fast and Furious because that was a terrible, terrible program that directly ended up with the deaths of Border Patrol agents. We know they did because they tracked the serial numbers to the program. Okay.
You want to know why Eric Holder is such a bad choice, though, Nick? Because there is a reason to impeach him.
Right.
Since there's a reason to impeach him, that's why the whole point is there's no reason to impeach him. It would purely be used for a political purpose, just to embarrass someone, unless you listen to us and do what we want. If you want to make it that you don't have any statute of limitations and no crime and not holding any office, in that case, we can pick any one of your heroes and humiliate them just for the purpose of humiliating them. We'll find something on RBG and say that she should be impeached. And it doesn't matter that she's not going to be able to run for office anymore. We don't care about about that. We just want to stain her legacy just for the purposes of being vindictive, because that's what this is. You're just being vindictive. You hate Trump and you're just being vindictive.
Right.
And that's how you make that point much more powerfully than bringing up someone who probably should have been impeached.
Right. Probably should have been impeached. Did likely perjure himself. I mean, you know, there's all sorts of ways to impeach Eric Holder. And when he left office, we're not talking that this is a popular guy leaving office as Attorney General. Obama replaced him midterm. I mean, that's not the sign of a super successful Attorney General. So anyway, Jason McConnell says, next time I find myself between Lake Street and Hiawatha, I will be fully armed with my own velvet rope. If it can contain an alt-right insurrection, then it can surely hold a BLM riot. Oh, no. Okay. Let's see. Where are we? This is a dangerous, slippery slope that the Senate should be careful to avoid. Were it otherwise, a future House could impeach former Vice President Biden for his obstruction of justice in setting up the Russia hoax circa 2016. While he could not be removed from the vice presidency because his term ended in 2017, he could be barred from holding future office. That's a good one. The same flawed logic the House managers advanced could apply to former Secretary of State Clinton for her violations of 18 U.S.C. 793. Impeachment cannot and should not be allowed to devolve into a political weapon. See, again, they don't pick Holder.
Obama.
In here.
Why would you pick Obama for like tapping wires, for the IRS scandal? There's so many different ways they could have hit.
I think they're picking people who theoretically could hold office again, whereas Obama
could hold presidents.
Yeah.
Right.
So think if they did Biden. Like in 2020 or 2022, Republicans sweep the House and Senate and get a massive 2/3 majority, like by some stretch of miracle, right?
Yeah.
Then they impeach Biden and remove him from office of vice presidency and restrict him from holding future offices as president.
God forbid. God forbid. You want President Kamala?
It'd be a weird proposition. Like, and that's what they need. I think they could have fleshed this out and highlighted the absurdity even more. Like they remove him from the vice presidency, prevent him from holding office that he's already in. This is dumb. This is dumb.
Yeah.
Setting aside the clear meaning of the text, the House manager's argument about the need for late impeachment with disqualification upon conviction to serve as a deterrence for presidential wrongdoing is also unfounded. A president who left office is not in any way above the law, as the Constitution states he or she is like any other citizen and can be tried in a court of law. From a political standpoint as well, an officer who has left office and is seeking to return faces the ultimate political check, even without disqualification, the electorate. It is almost laughable that the House managers, who spent 4 years pretending that Mr. Trump was completely ineffective and illegitimate, are now so worried that he might win again that they seek to illegally impair him. Accordingly, the Senate does not have the power to try a former president and should dismiss the article of impeachment. Any other outcome would do profound and lasting damage to the institution of the presidency. In this political climate, we have seen statues and monuments of former presidents attacked because the values of their times were not in line with supposed modern sensibilities. If this impeachment of a former president is allowed to go forward, we could expect dozens more to follow from potentially both sides of the aisle, depending on which party happens to be in the majority. Quote, future Congresses would judge the conduct of presidents and other civil officers from the perspective of a different political and social milieu. From the vantage point of subsequent Congresses, President Clinton may have had a Me Too problem. President Lyndon Johnson evidently spoke disparagingly about race. Evidently! President George W. Bush lied to the public about domestic surveillance and so on. And although historical judgment may at times be healthy, the power of impeachment comes with tangible penalties. End quote. It is also true that even if the Senate were to convict him without jurisdiction, such a decision would not go unchallenged. If Mr. Trump decides to run again, any non-binding disqualification from an unauthorized Senate vote could and would be challenged in a court of law. As scholars across the spectrum have agreed, certain aspects of impeachment are justiciable. For example, in a case like this, where the president was tried by someone other than the Chief Justice, a court would be likely to hear the matter on review. I agree. I think if there is a reviewable aspect of this on its face, you've got the jurisdictional aspect, but you really do have the matter of, is he a president because the Chief Justice is not presiding? Should the Chief Justice have presided? Why didn't the Chief Justice preside? And if it was Roberts who actually made that decision, I think he signaled, go ahead and bring the challenge to this impeachment if it goes through. Like, to his credit, if he decided I'm not going to show up, then he's signaling, if this impeachment goes through, bring it to the Supreme Court and we're going to undo the impeachment.
Yeah. That's the only way to read it. Like, it's almost like he's saying, I don't want to waste my time with this garbage again. Especially now that he's not there, he's not the president. So I'm not wasting my time with this garbage.
Unless Roberts was never invited. That's the alternative, right? Like
I don't see how he was not invited. I mean,
I don't see it either. I just don't know.
If you're the Democrats, you want him there. The Democrats want him there more than anyone because it gives legitimacy to where they're coming from.
Right. I agree. They should, but again, not having enough information about how the process occurs, I'm just accounting for the possibility that it didn't.
Okay, well, based on how they started on day one, we have to assume that they know what they're doing. And since they know what they're doing, we have to assume that they would have the proper strategy to say that our case is stronger if we have John Roberts sitting up there presiding, and that they're not stupid enough to miss that. And that being the case, they must have tried to get him, and John Roberts said, I'm sorry, I'm not coming. Yeah. That's the only way to interpret it.
Well, I would love a written thing from Roberts. Just a little note that says, just a note that says, I will not be attending this impeachment trial.
Gone fishing.
Yeah. I'm busy deciding real cases. The article of impeachment violates Mr. Trump's First Amendment rights. Okay, so now we're on to this argument. Aside from...
So I want to ask you this, Nick. I want to pause you for a second. I just want to ask you a quick question, because we're on page 37 out of 78, which is 41 pages left.
Right.
So my question to you is this. I don't see how feasibly you could even read these pages, the 40 pages, if we didn't talk at all and finish. So my question is this. Are you looking at going to night 3, which if you do, I'm cool with that, or do you want to skim through and like focus on certain arguments and go forward that way? I'm good with either way you want to do it. I'm saying this now. I would say this to you in private, the same I'm saying to now in front of your audience. I'm good with either one of them. I'll come back here for a third night if you want. If you want to stop after 2 nights and just say, okay, I'm done with this brief, that's fine. Or if you want, the reason I'm bringing this up now is if you want, we can sort of skim and say, okay, these arguments are ones which seem a little fresh that we haven't discussed at all. Maybe we'll read those and focus on those and get that done over the next hour, hour and a half, and then be done with this. Your call, any of those 3.
The chat, I would defer to the chat on this. They used to have a poll option, but I don't see a way to do a poll in the chat anymore. It would be great to have the whole thing. But I'm fine with another one tomorrow because I think, you know, the House is going, or the Senate trial is going to continue. I'm going to continue covering it. So I think we'll have other stuff to talk about as well. So if you're game, I'm game.
Dude, but you got to get me, like, I'm counting like 300 members a day out of this. That's what I need 300 subs a day. I'm not getting the dollars. Just need people sign up, get your moderators to like be pimping Good Lawgic, and then I'm good to go.
Okay, guys, here's what you need to do. Hit Good Logic's subscription button. His link is in the description of this video. Go hit that subscribe button and the bell so he knows that you like him. Go do that.
Let me show me that level of love and I'm good to go.
Look, we're lawyers. We need affirmation.
I'm also going to need, this is one other thing I'm asking you, Nick, because I don't think you got a chance to upload last night's video. I don't know how that works with uploading a live stream.
So it's actually, I have a backup channel for all live streams now. And so it's moved over there.
Oh, okay. Because I need that link, because I had a few people that asked me where they could watch like last night's show. So I want to be able to like, because my wife's asleep right now, so she sort of like wants to catch it like, you know, tomorrow.
Yeah.
So yeah, I gotta know where those links are so this way I can sort of share that with people, and maybe if I find something that I said that I particularly like, I can share it with my audience also. I'm DMing it to you right now just so I don't forget. There's the link to it. But the pinned comment, if to the chat, the pinned comment at the top of your chat bar, if you click on that, has a link to the archive channel. You can go and subscribe over there. And I start the uploads immediately following the conclusion of a live stream, and they tend to go up. And as soon as they're up over there fully, I take them down over here. And that has to do with YouTube analytics and YouTube's algorithm. And I hate it, but YouTube is forcing the hand on that one. But don't you get like 20,000? I thought you get like 15,000 people who watch this later on. Like people will like peeking on it later.
Here's
So how do they find it?
here's the problem with how YouTube does things. If you do short videos, YouTube says, okay, this person makes videos that are 8 to 10 minutes long, and they're about these subjects. I'm going to deliver those videos to people who are interested in those subjects in 8 to 10 minute bits or whatever.
Mm-hmm.
If you suddenly start throwing in 3-hour live streams, YouTube goes, this person does 3-hour long content, and I'm going to deliver these videos to people who watch 3-hour long content.
To the nine people on the planet who watch 3-hour videos.
Right. It confuses the distribution of it, and it frustrates your ability to grow. So unfortunately, lots of streamers do it this way. I hate it. I wish we could just segregate it out and say, like, don't even include this in the distribution model. Please just distribute my short stuff, because that's how the channel grows. That's how, that stuff happens. And this is for a particular type of audience, and they will find it on their own, because there are less people who like to watch the longer content than there are the shorter stuff. And so YouTube just, it's dumb in how it does it. They've submitted too much to the machine learning, in my opinion.
Got it. Okay. Let's move along.
Okay. There is a straw poll, by the way, guys. You can check it out if you want. Should Nick and Joe do another stream? That overwhelmingly is yes right now, but there's only 22 votes. So someone send a truck full of votes late to that poll and see what happens. Bad Vibes.
Let's get the Democrats on this.
Nick, are you being a boomer groomer and trying to get a regular sidekick co-host? Well, no, but I like to have a roster of people who enjoy coming on the show. That's always fun. I think it adds dynamic and perspective. Okay. The article of impeachment violates Mr. Trump's First Amendment rights. So right now I'm operating under the assumption that we're going to just keep powering through.
Do it.
So,
good.
Aside from the fact that it does not constitute a crime, let alone a high crime or misdemeanor, President Trump's speech at the January 6, 2021 event fell well within the norms of political speech that is protected by the First Amendment, and a triumph for that would be to do a grave injustice to the freedom of speech in this country. Perhaps in realization that Mr. Trump's speech was clearly within the bounds of the protections afforded by the First Amendment, the House managers attempt to erect artificial roadblocks. Oh, they're inciting erections now. Erect artificial roadblocks to prevent the Senate from even considering First Amendment principles in these impeachment proceedings. These efforts, as fully discussed below, are complete sophistry that should be rejected by the senators who are duty-bound to consider and apply the First Amendment. Okay, what do you think about the overall thrust of this argument? Is the First Amendment defense worthy of making?
Definitely. Because, I mean, you and I both know that this is not incitement. First Amendment is the most basic. You know what? The First Amendment is the one thing that sort of, I'm going to take that back. Not the one thing. It's one of 4,000 things that really splits red from blue. And you're preaching to your choir here about, and the people sitting red really believe in First Amendment. You're not trying to convince the people on the blue side. So since the people who are from Louisiana who might be voting against you in some stupid vote that's taken on day one, they strongly believe in First Amendment rights. And you want to basically say that this is another step that the left is taking toward infringing on our very fundamental basic right. First words out of the Constitution is freedom of speech. Mm-hmm. That's even before religion or peaceably assemble. The very first thing, freedom of speech. So, yeah, that's so hitting on that is preaching to your choir. You want to preach to your choir here when you're trying to hold court. So I think that they would be stupid to leave this out, and I think that it should come really early here. I think it's an important thing. So. Okay.
Yeah, I agree largely. The Senate cannot
disagree. You're allowed to disagree with me. I don't.
Well, I know I am, but I'm not going to at this point.
Okay.
The Senate cannot disregard the First Amendment and the Supreme Court's long-established free speech jurisprudence. House managers, trialmen are... Now, I mean, they can. So I'm going to disagree with the wording of the brief. They can disregard it. That is the impeachment power, is to decide just to ignore everything if they want.
Well, can they? Can they really are they allowed to disregard the First Amendment?
I mean,
what's the right to do that?
What's the remedy? Like, let's say 99 senators all vote, we don't care that he has a free speech right. We don't like it. He's out. and one senator abstains. Like, he can't go to the Supreme Court and say, protect me, bro, I had free speech. Like, they're not going to step in on that.
Right. So, okay. I think it's calling to their moral obligation.
Yeah. No, I agree. I'm being a jerk. The House Manager's trial memorandum expressly advocates for the Senate to disregard First Amendment principles, stating, quote, "The First Amendment does not apply at all to an impeachment proceeding." Now, see, I think it does apply. I just don't think they're bound by it. That's what I'm saying. Like, because there is just the practical element of it is that there's no review. So how are you going to?
They are because they have their duty bound. They swore an oath to uphold the Constitution.
That's true. Oh,
so they'd be violating their oath.
Yeah, they should be impeached.
Yeah,
you vote against Donald Trump, you should be impeached. Piece of garbage. Dick Durbin.
Dick Durbin.
In doing so, the House Manager shockingly invites senators to violate their own oaths. Well, there you go. To uphold the Constitution and the bedrock principle established over 200 years ago that the Supreme Court is the final arbiter of whether congressional acts are consistent with the Constitution. There is no actual precedent for this confounding precept offered in the House Manager's brief. The managers astonishingly cite to a few recent internet blogs. Oh man, look at the disdain italicizing blogs. The First Amendment is widely understood as prohibiting Congress from abridging the freedom of speech or the right of people to peaceably assemble in all aspects of state action in all three branches of government. Congress may not take action that would abridge the freedom of speech. Indeed, senators take an oath of office, which includes an oath to support and defend the Constitution of the United States. The Constitution, of course, includes the Bill of Rights, including the First Amendment. This means inevitably that senators cannot do what the House Managers urge. The Senate cannot blithely cast aside the First Amendment and the Supreme Court's long-established free speech jurisprudence when passing judgment on articles of impeachment. The Constitution must, at minimum, serve as a limitation on the ability of Congress to impeach for high crimes and misdemeanors, as noted by constitutional scholar a few years ago. Was that Dershowitz? If that were not
wasn't
the case,
it Turley?
They cite who are they citing? God, I don't know. Their footnotes annoying to read. Oh, they don't actually footnote that one. Never mind. If that were not the case, there would be a host of internal contradictions within the Constitution that could not have been intended by the framers. Quote, is probably cited on the next page. Additional negative restrictions would also extend from the panoply of protections in the Bill of Rights. For example, an officer could not be removed from office for refusing to self-incriminate, Fifth Amendment, or seeking the assistance of counsel in a criminal prosecution, Sixth Amendment. Whatever high crimes and misdemeanors means, it cannot include conduct that is itself protected by the Constitution. Such would be an internal contradiction. Or to frame it in modern doctrine, it would amount to an unconstitutional condition, punishing a person for exercising a right protected by the Constitution. That's Josh Blackman that they quoted there.
Yep.
So, okay. The position advanced by House Managers is essentially an impeachment standard without congressional guardrails, unmoored to any specific legal tests other than the unbridled whims of the House Managers. That distinctly was not what the framers intended when they expressly limited impeachable offenses to high crimes and misdemeanors. The framers of the Constitution...
By the way, I will point out to you, the reason I thought it was Charlie's because Charlie's the one who spoke, one of the people who spoke at the last impeachment trial. Right. I think it is a little ironic that Castor, and I would be mocking Castor and Schoen about the fact, if I was on the other side, that they were like deriding blogs and then they cite a blog. It's almost like they're like sort of like bashing on them for citing blogs, and then all of a sudden they're citing Josh Blogman from his lawfareblog.com.
Yeah, it even says blog in the website.
Yeah, it's pretty. That's a little duplicitous right there, but.
Let's see. The framers of the Constitution were keenly aware of the danger of any impeachment process that would make the president the mere creature of the legislature. Such an arrangement would constitute nothing less than a violation of the fundamental principle of good government. And they should have said, and separation of powers. Right there.
Yeah.
Founding Father James Wilson, who is a renowned legal scholar, served as one of the 6 initial Supreme Court justices and was a major force in drafting the Constitution, plainly stated in his law lectures that lawful and constitutional conduct may not be used as an impeachable offense. Quote, the doctrine of impeachments is of high import in the constitutions of free states. On one hand, the most powerful magistrate should be amenable to the law. On the other hand, elevated characters should not be sacrificed merely on account of their elevation. No one should be secure while he violates the Constitution and the laws. Everyone should be secure while he observes them. Ooh.
Apparently, I bet he didn't write that on a blog either, the founding father. That was actually...
Well, I mean, they had a lot of them in 1789.
Yeah.
Let's see. The House manager's suggestion that the First Amendment does not apply to this impeachment process is untenable. It conflicts with common sense, the senator's oath of office, well-settled Supreme Court precedent, and the intent of the framers of the Constitution, such as James Wilson, who not only was a draftsman of the Constitution, but taught the first course on the new Constitution to President Washington and his cabinet at Philadelphia at the University of Pennsylvania in 1789. The Senate should soundly reject the manager's invitation to disregard the Constitution. That's a cool title, right? Like, he's the first con law professor in the U.S. directly to the president of the United States. That's great.
Yeah, yeah, you don't really get higher billing than that, right? in the legal world, that's
like he wrote it, he taught it, and then he judged it.
And then he judged it for Washington.
Yeah.
he wrote this law. Yeah, he worded all this for us. That's not like one of the founding fathers. That's Zeus of the founding fathers.
That's a good one. Medical Mania says, getting my Ouija board out to try to summon my grandparents, N equals 4, to vote yes on this and to also subscribe to Joe's channel, Pimping the Dead. Keep up the good work, guys. Oh, no. The dead don't vote. YouTube told me. Mr. Trump, as an elected official, has First Amendment rights to freely engage in political speech. Hold on just a second. I got to make sure I'm not missing something over here. Okay. Another roadblock to the House manager's use is the legally unsupported idea that because Mr. Trump was an elected official, specifically the president, he has fewer rights under the First Amendment than everyone else in the United States. This, too, is sophistry. The opposite is true. The Supreme Court of the United States has long held that the First Amendment's right to freedom of speech protects elected officials such as Mr. Trump. The House manager's argument to the contrary both ignores well-established precedent and erodes the constitutional principles guiding this august body. In fact, the argument of the House manager so materially omits the relevant constitutional precepts that an extended discussion becomes both necessary and warranted, particularly in light of the public commentary relied upon in the House trial memorandum. There can be no dispute that elected public officials engage in protected free speech when they speak out on investigations of voting regularity and fairness. The Supreme Court held that an elected sheriff who spoke out on an investigation of voting patterns and even communicated with a sitting grand jury via open letter was protected by the First Amendment from punitive action by another group of elected officers for publishing views honestly held and contrary to those advocated by his accusers in the other political party. Justice Brennan, writing for the majority in Wood versus Georgia, good, pick a liberal, went so far as to make the protection of an elected public official a core First Amendment principle because the voting controversy at issue directly affected the sheriff's political career. Quote, the petitioner was an elected official and had the right to enter the field of political controversy, particularly where his political life was at stake. The role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on matters of current public importance. And I think we see this codified in federal employment law, right? Where you can't be fired for a violation for speech that you make as a federal employee without notice and an opportunity to be heard. You have to have due process on the removal.
So you want to argue now, you want to twist that and say, if we're going to protect some train conductor for his free speech from being able to lose his job, so how are you going to say that same protection shouldn't apply to the job of President of the United States?
Yeah.
I like it. You're using a whole new employment, labor law defense.
Yeah, because I don't remember the case. I'm remembering back to random law school things because I don't do federal employment practice. But I know that there was like a cop who said some things and they wanted to fire him specifically for what he said. And he's like, wait, I have a right to free speech, bro. And they had a right. He had a right to a notice and opportunity. He had a right to substantive due process. in
Wow.
his termination. So
Wow. That's powerful legal reasoning right there. I mean, I'm saying it's creative, and it sounds like there probably is a hole in this argument somewhere, and yet I can't think of what it is. I think it actually is pretty reasonable. It's far stronger than a lot of the other legal arguments that we've been hearing from the left. That's for sure.
you gotta pull out all the guns, every aspect.
Impeachment, impeachment is wrong because of labor law.
What about this? What about
So
this? Do you
weird.
go back and say that the only safeguard against the collapse of ancient Greece and ancient Rome was the United States Congress? Is that an argument
What?
that you make?
What?
Just hear me out on this. Do you argue that the only safeguard against the collapse of ancient Greece and ancient Rome is the United States Congress?
I don't even understand how that argument. I'm confused.
We'll have to ask Bruce Castor. Because that's one of the things he said.
I walked right into that. You're totally punishing me here for not watching Bruce Castor today.
It was so bad. Oh, it was so bad.
I sort of feel like you're like setting up that joke and setting it up, and I just was like to like that punchline that you just wanted to wham, and I just was like leaning in closer and closer until you got like see like the whites of my eyes, and then you just like bam, and like I didn't even realize it was upon me until I was like overcome with like yeah. I guess it was really terrible.
I know
You're saying it was memorably terrible.
Oh man, it was really awful. And I don't know how he got there. I know that's not what he was trying to say, but those were the actual words he used. Like he actually said, because he makes this long meandering point about republics and the legislature and the sanctity of it. And he does end up saying that the only safeguard against the collapse of ancient Greece and ancient Rome was the United States legislature. And I'm like, what?
Okay, so I'm going to explain to you what happened here.
Yeah.
Explain to you what happened to Mr. Castor. He watched my speech about the St. Vitus dance, and he's like, oh, I remember this whole analogy here that they're trying to dance on the bridge and dance on the bridge, and he basically saw that, and he's like, I got to tie this all in here to what Joe said, and he just got confused by it. He could have paid me, like, seriously, just a couple of grand. I would have got on the phone with him and walked him through it. And
I think
this
you should have
entire
just
scene...
taken your video, put it up to the mic, and mouthed along, right? Like a bad dub job.
Yeah, any of you here who have not checked out that video, you really should. It's a really good 10-minute speech that obviously, based on Nick's opinion here, would have buried whatever came out of Castor or Sean's mouth today. Although
like I said,
that bar is really low.
I don't think that's the argument that Castor was intending to make when he walked down that road. He just completely got lost in the middle of it. And again, this is why you don't change the plan. I mean, presumably these attorneys spent yesterday, probably 8 to 10 hours each, literally reading their speeches and going through them and refining them and working on them in front of an audience, in front of a recording, in front of a mirror, in front of the wall, while they're brushing their teeth. They're saying the same thing, and they're billing $1,000 an hour. Like, of course you're going to keep practicing your speech. Just do it.
I'll tell you this much. If you're Bruce Castor, it's as bad as you say it was. No one's probably beating him up harder than he is beating up himself tonight.
I'm sure.
That he realizes how awful he was and the humiliation that he has, and that he's basically like, he's taking a hit from something tonight. Like I would think he's drinking or pumping something to get past this one, because
then I'm not doing my job hard enough. We have to hit Castor harder than he can hit himself on this one. No, it's bad. And the reports are that Trump is pissed, by the way. That's the reporting I've seen.
Well, I don't need a report to know that.
Right.
Come on.
Okay, back to this. To paraphrase Wood, if Mr. Trump can be silenced in this manner by Congress, the constitutional problem becomes evident. A difference of political opinion expressed in speech on an issue of voting irregularity cannot be punishable where all that was done was to encourage investigation of voting irregularities and peaceful political speech. Great point. That's great. If Wood alone was not dispositive of Mr. Trump's free speech rights as an elected official to address public controversies such as voting irregularities and the authority of officials certifying votes, the Supreme Court emphatically held shortly after Wood that a legislature cannot punish an elected official for protected political speech. Bond versus Floyd squarely addresses the question of an elected official's punishment by a legislature for statements alleged to have incited public violation of the law, unequivocally rejecting the idea that an elected official is entitled to lesser or no protection under the First Amendment. When the state argued that even though such a citizen might be protected by his First Amendment rights, the state may nonetheless apply a stricter standard to its legislators, the Supreme Court responded tersely, "We do not agree," and held the action of the legislature against the elected official unconstitutional and in violation of his First Amendment rights. 109. What is this case? Bond versus Floyd.
That's powerful.
I'm throwing Bond versus Floyd into my search for some later research here because that's I want to know the context of that. I want to see if they've got that.
Well, they're actually explaining it further in the Bond case. So why don't you read a little further?
Going further, the Supreme Court held that the Georgia House of Representatives was in fact forbidden by the First Amendment from punishing Bond for advocating against the policy of the United States. It began by once again rejecting outright the argument that an elected official could be held to any higher standard, or that the Georgia House could limit its legislators' capacity to discuss their views of local or national policy. Justice Brennan, once again writing for the majority, went on to reaffirm the constitutional shield around the speech of elected officials, even extending it to statements deemed erroneous. Quote, "The manifest function of the First Amendment is a representative government requires that legislators be given the widest latitude to express their views on issues of policy. The central commitment of the First Amendment, as summarized in the opinion of the court in New York Times versus Sullivan, is that debate on public issues should be uninhibited, robust, and wide open. We think the rationale of the New York Times case disposes of the claim that Bond's statements fell outside the range of constitutional protection. Just as erroneous statements must be protected to give freedom of expression the breathing space it needs to survive, so statements criticizing public policy and the implementation of it must be similarly protected. The state argues that the New York Times principle should not be extended to statements by a legislator because the policy of encouraging free debate about government operations only applies to the citizen critic of his government. We find no support for this distinction in the New York Times case or in any other decision of this court. The interest of the public in hearing all sides of a public issue is hardly advanced by extending more protection to citizen critics than to legislators. Legislators have an objection to take positions on controversial political questions.
Obligation. Legislators have an obligation.
Oh, have an obligation, sorry, to take positions on controversial political questions so that their constituents can be fully informed by them and be better able to access their qualifications for office so they may be represented in governmental debates by the person they have elected to represent them. This is what I was talking about with Marjorie Taylor Greene. Like, even though, I don't really care what she said in general. I don't agree with the idea of censure or stripping of power of an elected official because, for better or worse, the public elected them. And that's to tell a group of people, I'm sorry that you elected this person we don't like. They don't get to talk.
I'll tell you, as a Jew, when I first heard her statements, I was saying that's anti-Semitic. What she was saying was anti-Semitic.
Sure.
In fact, in general, whenever anyone mentions Rothschild,
are you saying there isn't a secret Jew laser?
Believe it or not, at least look, any of the Jew meetings I've attended, no one's brought that up. Trust me, we got much better stuff than lasers.
Terrific. We have way better than lasers. Lasers are last
way
year.
Better.
We've got waves. We've got microwaves. We've got gamma waves.
Right. So, at the same time, even though, and I'll tell you, as someone, obviously Jews have had their share of people that face their share of persecution over the centuries. So, yeah, when someone like that is in public office, that is disconcerting. On the same time, when I heard her explain where she was coming from and how she's like, look, I can't get truth from the news. I poked around in various sites. I did look at Q. and I investigated it. I don't subscribe to what their position is, anymore. I still have questions. Everything that she said there, I was like, I've said the same thing,
Yeah.
and she's like, I don't believe that, I don't believe the statements that I made back then are accurate anymore. You know, but that was part of my finding my truth, as finding the truth, because it's not, because the truth isn't served up to us anymore. We can't get it from the news. We can't get it from anywhere. So if someone is exploring it and they look into Q and they start thinking that, hey, you know what, maybe this makes sense, or let me see whether this is logical, and that's the road they go down. Along the way, they come across anti-Semitic stuff. That's not surprising to me at all. And if she believed it and she's saying now she doesn't, I'm certainly willing to give her another shot. And I'm like, okay, you know what? She seems more trustworthy than 90% of her peers in Congress. So
Yep.
God bless. Why should anyone be taking her off? And if I'm someone who's Jewish who heard her statements and said, I don't see why she's being taken off of anything. I can't understand. And one of the things that makes me so angry with the left is when they take more offense over something than the people who are supposedly offended by it.
Oh,
Like,
yeah.
it's like no Native Americans care at all about the Washington Redskins, but all these white liberal college kids are like, oh my God, the calamity. How can you be so cruel that first you stole their land and threw them off, and now you're making fun of them by calling them Redskins? Let me tell you this. If there was a football team out there, I don't care what state you're from, what city you're from, you want to call yourself the Indianapolis Kikes, God bless you. I would love you for it. Okay? Because it is the ultimate sign of respect that's a real warrior, someone who's supposed to be feared. No one's calling themselves the tiger, the little lily ponds. No one's calling themselves the little fish sticks. So if someone wants to call themselves the Kikes, that's a compliment. Okay? I would wear a shirt that says Kikes all over it. Okay? I would get a football helmet. It'll have like a little Star of David and probably some guy with a big nose. I won't care. Okay? Because at the end of the day, it's a compliment. And all these people who are not Native Americans who are like, oh my gosh, it's so offensive, and they're more offended than the Cherokees themselves. It's like, what's wrong with you? Why are you so offended? No one else cares. So that's what they love to do. They love to take up the banner for people, for the invisible people who are not offended. And this is the same thing over here. They're standing up for me and protecting me from Marjorie Taylor Greene. Trust me, I'm much more scared of Ilhan Omar and all the people on the left than I am from Marjorie Taylor Greene being misguided into thinking that Jews are up in space shooting down lasers from their eyes. I'm okay with that.
What
All right?
happens?
Rant is over.
What happens when Indianapolis squares off against the Montana Merchants? I mean, how does the news even report on this game? I don't know what to do.
All right, my rant is over.
I would make you that shirt, but Teespring would immediately remove me from their platform. Oh my God, that was beautiful. Mr. Trump.
That's what you get. That's what you get when you subscribe to Good Lawgic. All right.
Yeah.
Or that's why I come on this show. That's why you bring me on here, because I don't hold anything back. I'm telling you the way it is.
No, I mean, you made.
Let's get moving.
On that the first stream we did, you made the dark joke.
Yes, the dark joke.
Okay.
I don't repeat my humor, so I'm not doing it again.
Yeah, no. So. That's fine. Real quick, people are asking, since Parler's gone, you had a show about Martin Bettik that was on Parler, but I don't know that ended up.
No, Martin Bettik, that actually I think was an offshoot from our show. He basically made a comment based on something on the show. Like, I think because of that dark joke that I made, so that guy Martin Bettik basically was saying that I was like, I don't know, some fake Jew, because lots of people, that's what everyone's going to look to do. Right. They're going to look to become fake Orthodox Jews. There's a spate out there. There's this rash of all these fake Jew imposters, and I was obviously one of them. That I was like basically,
I know
not really
I'm running
Jewish.
To convert. Right.
Yeah. No. That's the thing. I wasn't looking to actually convert. I was looking to fake being an Orthodox Jew solely for the purpose of God knows what, because everyone is in love with the Orthodox Jews.
Yeah.
Okay. Is that really true? I mean, I know if I was going for like some urban studies degree, I would want to fake being black, or if I wanted to get a job in Harvard, I would fake being a Native American, and I'd sit there going, and like say like, I got the high cheekbones, look over here. But no one's faking being an Orthodox Jew. But apparently Martin Bettik thought that. So when I broke down for him, because he called me like a Nazi or something like that, and I basically took him apart I made a whole video about it, which was it was one of my more popular videos, which is my fight with the COO of Antifa, because that's what he called himself, the COO of Antifa. It's a pretty funny video.
He
It got
got
away pretty much like what I just did.
he got banned off of Twitter
Which is
permanently.
surprising. It's almost like Twitter's trying to show, look, we're really not biased against the right because we're going to take off the crazies on the left. And I think it's really a matter of they're trying to show, they're trying to sort of cover themselves that like no one should think that this is bias against the right, even though they're clearly so ridiculously biased against the right that it's a joke to think otherwise. The only one
Yeah.
who can't see that is Senator Hirono, but everyone else can see it.
I found it amazing because that person has been I will classify it as literally harassing me on Twitter. I mean, as much as you can harass someone on a platform where you can just turn it off.
Oh,
But
so you were happy that he was taken off.
I'm indifferent. I don't care.
Yeah.
I don't want anyone silenced, so I wasn't like reporting him or anything. But
Mhm.
I do laugh that he's gone. But the thing is crazy because this person has spent at least a year commenting on basically every single tweet I've made everywhere with something
Really?
similar, like what he came at you with. Like he did that to
Yeah.
me. Like imagine every tweet that you made had that
Yeah.
person in the replies. Every
And I gotta
single
tell you
one.
something. It's an alpha move on your part that you never blocked him.
Yeah.
That's a sign of someone who, look, I believe in what I'm doing, and I'm not. It's a sign that you're not threatened. And I'll tell you something else. It's actually a very beta move to constantly follow anyone around and try and troll them like that. It's
It's
like
so
almost like
weird.
you're his purpose. It's almost that's the same way that Trump dominates all these people on the left. That they're so consumed with him that Brian Stelter is basically going around sniffing for his dirt. It's like a weird type of backward infatuation. The opposite of love is not hate, it's indifference.
Yeah.
If you really don't love someone, the opposite of love is like, I don't even think about you. It's really, you're still around. That's what the opposite of love is. The hate is not the opposite of love. The hate is when you're still consumed with someone that's like they're still inside, they're inside your head. That's a it's a twisted form of love, but it's the same type of thing from like a little bit of a warped perspective, but it's certainly not the opposite of love. So that's why I would say this guy, CEO of Antifa, he definitely had some sort of weird kind of perversion.
Yeah.
Um, to be
Yeah.
following you that long. Look, if he saw one or two things you said, and commented on it, like I'll tell you this much: I every once in a while on Twitter, I'll dog Brian Stelter because I think he's a joke, and I kind of get a kick out of it. But I don't do it to every tweet he writes. It's like once or twice a week, maybe. And recently, in the last month, maybe one thing I saw that he wrote that just made me laugh at what a clown he is. But yeah, to
Yeah.
be following someone relentlessly is a weird type of
It's very strange.
psyche.
It's
Yeah.
very I tried just sending him nudes. It didn't work. Bad Vibe says
Is that how you chase people off?
no, it's how I draw them in. You got to convert them. You got to convert them to viewers. Bad Vibe says the Minnesota saltines, not able to say the word crackers, thin salted bread snack usually used with soup. The Minnesota crackers. Yes, I love it.
Nice.
Amateur Ant says 20 years from now, Trump will be vindicated for trying to save the Republic. Beijing Biden pervertus will be a shart in the wind trying to sniff kids in the afterlife. Don't worry, Hunter will fill his shoes. Gross. Fill him with meth and then eat him. Okay, let's get through this section and then we'll wrap up.
Yep.
Mr.
What
Trump,
is this section? Where are we getting to?
to the next subheading, whatever it is.
Okay, fine. Like page 47. Okay, fine.
Mr. Trump's statements and advocacy of his political opinions, abhorred by the opponents of freedom of speech in the House as they may be, is no less protected than bond speech. Mr. Trump, having been elected nationally, was elected to be the voice for his national constituency. It is undeniable that the First Amendment's protections flow to him as an elected official, where he was, as would, addressing the electoral integrity issues essential to his career that he had consistently advocated, a position unpopular with his political opponents. I do actually really like the very lawyerly way they're structuring this argument. Furthermore, as Mr. Trump expressly urged rally participants to peacefully and patriotically make your voices heard on January 6th, his political speech falls squarely within the protections of the First Amendment under clear Supreme Court precedent, as fully discussed below, and he thus cannot be convicted by a Senate sworn to uphold the Constitution. Contrary to these express holdings of the Supreme Court, as announced more than 50 years ago, the House managers assert in their memorandum that the First Amendment does not shield public officials who occupy sensitive policy-making positions from adverse actions when their speech undermines important government interests. In making this spurious claim, the managers rely on 2 cases concerning appointed public employees, having inexplicably failed to bring to the Senate's attention the squarely and obviously on-point Supreme Court authority concerning elected public officials discussed at length supra. The House managers' 2 cases, however, address the wholly different situation of public defenders and sheriff's office employees suffering unconstitutional dismissals based on party affiliation. Those individuals were protected from employment termination, not impeachment, because they were not policymakers or possessors of confidential information, and thus their private political beliefs could not interfere with their duties. Such cases cannot serve as a basis for a First Amendment analysis of Mr. Trump, or in fact any president, because elected officials are different in kind from non-elected public employees under the First Amendment. So this goes against the argument I was making earlier, by the way, the labor argument. The Supreme Court, in fact, expressly rejected the House manager's First Amendment argument when confronting the voting investigation speech at issue in Wood. Justice Brennan examined the line of cases addressing termination of non-elected public employees and found it inapplicable to the case of the elected sheriff. Quote, petitioner was not a civil servant but an elected official, and hence this is not a case like United Public Workers versus Mitchell, in which this court held that Congress has the power to circumscribe the political activities of federal employees in their career public service. As Mitchell was the case relied upon in Elrod and Branty, and its factual predicate was expressly rejected as a basis for evaluation of an elected public official's First Amendment rights in Wood, the House managers have built their case against the First Amendment upon the proverbial foundation of sand, and have no support for their argument that Mr. Trump lacks protection under the First Amendment, as all Supreme Court authority is directly contrary to their assertion. Okay, so that's the end of the subsection there. I think this is good argument. I think they're laying out now. The conflicting part is I still don't know the remedy. Like, I have a hard time going. Let's say we're 2 years into an administration. The president comes out and says something that the other party doesn't like, and they impeach him and they remove him. And he goes to the Supreme Court and says, they can't remove me. That was protected speech. I have a hard time seeing the Supreme Court go, you're right, you're not removed. I don't know how that functions.
Yeah, I don't think. You're raising an interesting question, which is, would the Supreme Court have a basis to weigh in on an impeachment after it's already been passed by 2/3 of the House? I mean, 2/3 of the Senate. Would they have even that? Are they stripped of that authority by that supermajority? I can't think of another situation. Where are there other situations where, I mean, it's only in passing an amendment, I guess, where you would have a supermajority. So the same way that they would have no power.
Overriding a veto.
Yeah. Well, okay, so an overriding a veto, that's a good point. So an overriding a veto.
And they could review that. I mean,
if a law, yeah, that's true. If a law passed that was overriding a veto, they could certainly make that unconstitutional because the Constitution is paramount over everything. So in that scenario, they would be able to override that. So maybe you could say that this is similarly like I mean, the reason we have 2/3 majority here is because it's pretty much like overriding a veto. That's why they come to 2/3, because you're obviously going against the president over here. So you need a 2/3 majority. So that being the case, this would be a similar thing where, in theory, I guess the Supreme Court could weigh in on the validity of this of a decision here.
I mean, they certainly have weighed in on impeachments before. I mean, US v. Nixon, the other Nixon, is a case where they weighed in on the validity of an impeachment. They just found in favor of Congress's acts there.
But they're not weighing in on the conviction of an impeachment.
Right. Yeah.
Which is where we're dealing with the supermajority issue. So, but still, you make a fair point that they certainly can label any law, even if it was passed by a supermajority, as being unconstitutional. accordingly, since this is essentially a law, I mean, this is a bill of impeachment is a law that's being promoted from the House, coming to the Senate, and then they're basically, in order to pass it in the Senate, you have to convict him in the Senate with their 2/3 majority. So I would think that they still can vote against. The Supreme Court could rule it unconstitutional. So coming back to the context of this argument that they're making here, let me think. I just want to think this through because my brain's sort of contrary to the.
I'm let's see. Da, 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 da. I am trying. Okay, so the case that they cited, Bond, was about a congressman who got elected, but they refused to seat him. It turns out he was black, and this was in 1965. So that might have had
That's
something
a powerful
to do with
one.
it. Right.
Yeah, that's sort of a great one for smacking the Democrats in the face with.
Right. But it's
Like
not an
that-
impeachment at the same time. That's a refusal to seat.
Yeah, it's coming to the whole issue as far as free speech, though, and whether
Right.
you can punish someone despite their, whether you can use someone's free speech against them to keep them from their position. In making the Spurs claim the managers were on 2 games.
Bad Vibe says, you know, if the apple doesn't fall far from the tree, then maybe Biden happens to have an issue with a certain chemical dependency. It would explain why his mental stability is similar to someone living under a bridge. Oh, man. Yeah. It's interesting. I think they've made a good argument. I'm just not sure. It's because these are so rare, because the impeachment of presidents are so rare, there isn't a lot of case law around it. And the questions of whether or not a Supreme Court can even affect the outcome of the case is one of the preliminary questions I think they would have to ask. Like, the Supreme Court's going to ask that question. They're going to address it. That's what they're going to do. That's going to be one of the first matters is, can we even, we can hear this case. Can we affect the outcome? We decide that we can or we can't. And then if they decide they can, they'll go on and assess the merits of it. But I don't think we have a clear answer on whether or not they can do that.
Right. So this argument here that they're making is that the foundation for the argument, because the House managers apparently made an argument. I haven't really gone through the House managers brief, but apparently they're trying to refute what the House managers said, where they had made an argument saying that you can punish someone, a servant, for their speech, and in this case that they relied on, they're saying the case that you cited, they made a distinction between a civil servant and an elected official. Elected officials, you cannot circumscribe their speech. Since Trump is an elected official, you cannot circumscribe his speech. There's a difference between a civil servant, who I guess their speech could be, in theory, curtailed, and without being deemed a violation of the First Amendment, that would not apply to elected officials. And accordingly, and that their case they're cited distinguishes between civil servants and elected officials, and thereby they're saying that your own case is cutting back against the claims that you're trying to rely on it.
Yeah,
the point that you're trying to draw from it. So I think that's effective lawyering, which is basically something that no one but you and me are going to read, or any other lawyer who's sitting there. No, you know why? Because it's like people are like, okay, so they make this claim here based on this case. Like, I mean, maybe a few senators are looking at the legal rationale behind it.
I think my bet is that none of the senators are reading the actual briefs.
Probably not.
I cannot imagine.
Which is, by the way, that's the strongest argument as to why Castor and Schoen should have been reading the critical points.
Yes.
And starting off with that rather than waiting 45 minutes into their thing and then saying, oh, by the way, we wrote some really good work.
Yeah, I think that's the big takeaway that they should have from this is, you're not looking at a judge. You're not looking at a federal appeals court judge here. You're not writing for a federal appeals court judge who is going to read every page in the record, or his clerks are going to read them and summarize them. You're looking at Congress people who are out campaigning literally their entire lives and going on news conferences and pandering to the media and solidifying their bases and shoring up their votes and talking to fundraisers. They're not reading these. They're not going to read these briefs.
And several of them have the mental acuity of a Senator Hirono. So, like, you're talking over their heads anyway.
Yeah, because that chick is dumb. It's interesting. We'll see though. This section is coming over the next couple days, so they're not they weren't arguing this part. Well, this kind of does play into the constitutionality of it. They should have at least made a.
Okay, first of all, what time does everything pick up tomorrow? What time is this the resume?
11 noon your time.
Wow. Okay. So they're going to stick with this 12 o'clock schedule and work on these banker hours.
I think tomorrow may be 8 hours long.
Really? So you're going to go straight from that into this, basically.
I'm going to go straight from that into a bullet, I think. We'll see.
So then,
I don't know.
And you do Twitch when you're done here also, right? You basically have no life at all. You just constantly...
Look, I don't normally stream during the day. This is a special event. This is a potentially once in a lifetime thing where we have the impeachment of a former president of the United States. I mean, how often do you get to do that? Never.
That's true. That's true.
Imagine being a con law professor right now and standing in front of your class going, I don't know. My God, I don't know. They're just making shit up. I don't know what to do. I don't know what to tell you. I can't tell you. Because normally you're like, okay, I'm a con law professor. We have a big case. Here's Obamacare. Here's how they could rule on this. This is when I was in law school. They actually ruled on Obamacare while I was in con law, and we got the supplemental textbook that we had to add and include for the final. But so it's like, okay, we can talk about how they might rule on this, the things they're going to consider, all these things. Is this a tax? Is this a fee? Do they have the tax and spend? We can do that. Here, you have no idea what they're going to do.
Yeah.
You're like,
because they're like, well, in 1879,
yeah.
there was this Secretary of War who bailed out, and we're not really sure like what the Senate decided there and whether it's supporting which side. So this is what we have.
Yeah.
Go with that.
Pretty much. By the way, when they tried this against Nixon, they said they couldn't do it. But when they did it against Belknap, they said they could, but kind of couldn't.
Right.
It's so all up to a vote, and everything's made up. It's like that show, Whose Line Is It Anyway? It's like, oh, welcome to Whose Impeachment Is It Anyway? Where the votes are made up where the votes are made up and the law doesn't matter.
Right. Oh, nice. You just came up with that. That's pretty good.
Okay, well let's do super chats and wrap up the show. And then, so you're committed to being on tomorrow then?
I already made the promise. So like,
it's your funeral.
Let's not make a big thing about it. Okay. Let's just. The
only excuse I will accept is that
you just have to deliver your 300 subs per night. That's all I'm telling you.
The only excuse you have available is that a laser destroyed your house from orbit.
I'm in control of those lasers. I'm the one.
No, your card has been revoked for that football team you invented. Okay, let's get through these. Bad Dragonite says, unrelated, but CD Projekt Red got hacked, apparently, and they said they won't pay the hacker. Hacker said they'll release info to partner journalists. The cyber hacker memes write themselves. Sucks for the employees if their info was taken, though. Probably sucks for the customers, is what I'm going to say. Edris Rex says in lemon voice, I can do it. The dilithium crystals are pushed to the full. She's going to blow. LaPierre Hammer for prison says, pick FDR as a target. He committed actual, inarguable crimes against humanity, including mass enslavement, imprisonment, theft of property from civilians, especially on basis of race, and rape of double-digit number of U.S. Navy soldiers at Newport.
How did they leave out the atomic bomb? You left out the atomic... Oh, I guess that's Truman. Yeah, never mind. Sorry. It's 3 a.m.
Night of Hope says, oh my God, deja vu. You literally had this conversation about YouTube algorithm verbatim the first time. Don't do this again to me. Sorry, buddy. Not everybody watches every show. Soki Johnson says, the political establishment whores hate the people, the Constitution, and everything America stands for. That's why they are freaking out about Trump, because he's shown a light on the bullshit. And they are outraged that people are not obeying them anymore. Darth Vader says, yo, the court struck down Padme's case since that tape I sent of her swinging around Yoda's 15-inch Jedi penis proves she's a giant space whore. And with Yoda being in exile from paternity allegations against himself, paternity allegations himself, it was an easy win. Don't stick your dick in crazy. Well, thank you,
You
Darth
really don't get
Vader.
You really don't get the Rocky Horror Picture Show reference. You don't get that at all.
Really? No, I've never watched it.
You have to watch it because you'll see how it's like. It's not just okay. Do you know the story as far as how it became this big cult thing? At least,
yeah, how it was like really bad, but then everybody just celebrated how terrible it was, and they
and
all
they
got
would
together.
actually they would have midnight screenings like on every Saturday night, and people would dress up like the characters and act the part in front of the movie screen. Like
yeah, they still do them.
Yeah, and that's what I'm
Yeah.
saying is because there's such big fans of like this stupidity that they like can't get enough of it, and that's what I'm saying is that's your crew right here. They
Yeah,
basically they're
I'm
addicted to you. They're addicted to you. I think some of them like are growing in facial hair just like this out of like Nick respect.
good.
Yes, and you see, I actually I got you inspire me to get my beard on fleek.
You got to do it. You got to do it. I can't see who actually sent this one because my pinned comment is covering up their name, but it says, Nick, are you going to cover the Funimation lawsuit? Maybe. Funimation has I think a class action lawsuit for violations of the Americans with Disability Act. And good, because they're garbage. Superstitious Oblivious B says, Joe, so what do you know about Martin Bettik with Parlor Dead? No one can get the preview. We already talked about that. Batgoat says, will Joe eat a hot dog? It's kind of our thing now. We are the chat. Snark Mark says, people undersell the problem of being forced to choose from the talent pool of people willing to work for Orange Hitler and associated stigma. Look, Castor and Schoen are not schlub attorneys. Like, I've seen this a little bit like, oh, Trump was left with no other choice. If you're no other choice up until today are Castor and Schoen, you're really in good, highly qualified hands. I mean, this is not like, it's not like he hired me, right? Like some weirdo in a small town in Minnesota is the only guy willing to protect Trump or something like that. He hired extremely high profile attorneys who charge upper hundreds to thousands of dollars an hour and have been doing this for 35 years or longer. I think
it's pretty naive to assume that there's a dearth of attorneys who would be willing to accept a high profile case like this, which they know they're going to make hundreds of thousands, if not millions of dollars in legal fees. So I think it's you have to be pretty naive to assume that anyone, even if they think of Trump as Orange Hitler, which if you check out my video about me versus the CEO of Antifa, I rail against people who refer to anyone on either side of the aisle as Nazis or Hitler, as that you are the ones who are anti-Semitic. But putting that aside, because it is a pet peeve of mine, yeah, I think you might be overestimating the ethical morality of attorneys, that they're like, oh, I'm not working for this guy because I don't like him. No, this is a high profile case. This is a case which you're going to make tons of money on. This is a case you're going to remember forever. There are very few attorneys of any political conviction who would say, oh, I'm not taking. I mean, I guess some of them are worried about the backlash of Trump haters, but I think that overwhelming majority of attorneys of incredible talent would be ecstatic to take this case.
Yeah, I mean, so. and the very real possibility is that your firm is going to bill $500,000 in a matter of 3 weeks.
Yeah.
And then once that's done, there's no appeal, there's no drug out process. Like, you're gonna bill $500,000 in 3 weeks, and you're gonna get paid most likely for it.
Yep.
So I think I agree with you. The Knowledge says, hey, Nick, great guest tonight. Just finished your stream with Uncivil, and I thought I'd watch round 2. Have a shekel for all your streaming today. Oh, thank you. Well, come back tomorrow. There's more. Quasi-Quirky Creation says, many of the individuals cited by the Dems rebutted the citations on Twitter. Crowder showed these in time. Oh, very cool. Classical Positioning says, hate to ask, but what's it going to cost to just unleash Dershowitz? Or do you think this is a trump card being played to lead up to a stronger defense? No, I think they just biffed it today, and they weren't going to win today, though. That's probably an important thing to frame. They weren't going to win the constitutional argument today. Like, just
you weren't going to get 50 people to say, yeah, dismiss today. You weren't going to get that.
So they weren't going to win that today. They just screwed up. Today was the day to screw up, in all honesty. I mean, the next couple days they have to go ahead and recover and to make very strong arguments that they put in their brief that are really good. And they're going to recognize that they really screwed it up today. Castor specifically, if he even shows up. And the other lawyer, Vander, whatever, is going to be taking part of the role in the upcoming hearings. And I think they actually have a day or two before they get to go. So
what happens tomorrow? They're starting hearings tomorrow, or what happens?
Yes, they're starting the, I guess it's the House Manager's case in chief tomorrow.
Oh, great.
So
we're going to see testimony from people. Do we know the names of people who are testifying tomorrow?
Witnesses have to be approved by a simple majority vote. So the calling of witnesses is not solidified yet, although technically the Democrats do have a simple majority automatically. I'm not sure how this works because I don't know if Kamala Harris gets to show up and cast a tie-breaking vote.
I would think she would. I would think she would. Does this mean they can say the defense gets no witnesses at all if they want?
I don't know if they can do that. I think if they have, the question is whether or not they have witnesses at all.
Mm-hmm.
I don't know if it's individual, but maybe it is. It's possible, which would be really funny. Like if you think about it, nah, you don't get to have your witnesses.
Right. Well, you know what? That's what happened. That's what happened in the first impeachment in the House. They basically were like, we're going to run this show the way we want to.
Yeah.
And there's nothing you can do about it. And then we're going to pass articles of impeachment and say he's impeached. Ha, 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 we win.
Right.
So.
Yeah. So I don't know how they'll end up doing that, but we'll see tomorrow. We may get testimony. We may not. I really don't think it's in either party's best interest to offer much testimony. I mean, I know they're going to want to parade in like AOC and Rashida Tlaib, even though she wasn't there.
They're not witnesses. I mean, so like, what are they going to testify about?
Oh, AOC was a witness. She was
testimony
at the
would be
compound.
from AOC. Yeah, she was in the city of Washington D.C. when this whole thing went down. So she's obviously a vital witness.
Right.
But
But remember, they don't have federal rules of civil procedure on relevance of the witness. It's literally a vote so they can just vote her in. And I think the Romneys out there are going to vote with the Democrats on hearing any witness they present.
Yeah, that's for sure.
So I think we're going to get some real garbage testimony. It should be fun. Amateur Ant says, is it in the Constitution that people should rise up against the government when it no longer serves the people as intended? I think we are here. Technically, it's only in the Declaration of Independence, and if you consider that as an included preamble to the Constitution, then yes, but generally, it's not in the text of what we normally consider the Constitution itself.
That's not part of the Constitution. Constitution came 13 years after the Declaration of Independence.
But there's some people who consider that the Declaration was adopted as a preamble because that's where life, liberty, and the pursuit of happiness is enshrined and all that stuff. So, I mean, I'm just saying that's what some people do. But no, it's not in like the Constitution of the United States, starting at Article 1, Section 1. It's not there. A Giant Mess says, while some were violent, others were civil and taking selfies with officers at the Capitol. While at riots over the summer, they burned down buildings and shot kids. Exactly the same. Sure. Yeah, exactly. CJ says, impeach RBG in case she had a backup phylactery. Snubber 13 says, I don't know if you know him, but Ranting Monkey had a question for you. He said he sent it to your DMs. I do know him. Let's see. I was curious about your take on the constitutionality of the impeachment in light of the recent SCOTUS emoluments decision. Can you discuss on stream? Well, they're not impeaching him based on emoluments. So what is?
I'm taking a selfie while I'm with you.
Oh, okay.
Like I'm feeling like I'm barging into the Capitol right now. So that's why I was like
there you go.
Taking a selfie of the moment.
To answer the question though, the emoluments was dropped as moot, which I think is the Supreme Court indicating they don't really find the emoluments argument valid.
Hold on a second. Out in the Midwest, you call it emoluments, not emoluments? Is that like a New York thing?
I think it's one of those things where I've only ever read the word and I've never heard anyone competent say it. So,
Okay. I think I've only heard the emoluments clause. I've never heard emolument. But sometimes I know down south they buy insurance instead of insurance, and I don't really know what that means.
insurance.
Insurance.
Yeah.
You buy insurance or
I'm
insurance?
from the South originally, so yes, I
Oh,
buy
so
insurance.
yeah.
I don't buy that insurance. I buy
Yeah.
insurance. Yeah, but basically, there's no part of the emoluments in this impeachment, so I don't think it's relevant to the recent Supreme Court decision is relevant at all. It was funny watching the people who argued that case try and spin the dismissal of it as a win, though. That was great. Michael Martino says, "Thank you, your lawyerness. I'm waiting for this to come around. They did this to Trump. We've got a lot more to give to the father of the year. What a bunch of great kids he has." The Physicality channel says, "Donating to buy this guy a CPAC machine." This is when you were breathing into the mic. Amateur Ant says, do segments like Tim Pool the next day he posts his live stream and gets more money because people think it's new or they are slurs. I have thought about doing this. I need to go back to doing them. It's just a matter of the previous clips I was doing in live streams weren't working. So I've got to figure out a good system for it, but it is on the docket.
Robert, what are clips in the live streams? What is that?
So like, since I'm removing the live streams from the channel, uploading like a 5-minute segment as a standalone video.
Oh, yeah.
And like, hey, by the way, if you want more of this, you can check out the live streams type thing. That's what Tim Pool does. But the problem is when I was doing them before, they just were not landing at all. So I've got to figure out a better strategy for it. Robert Levito says, "I'd like to invite Joe to come on my show. I mean, I don't have a podcast, but the invitation is still open." Skeetneat says, "What about the Los Angeles Oven Dodgers to replace the Dodgers? By the way, Siege is the god of autism, and autistic people are the real Jews." So, I mean, I guess that's a compelling argument. I don't know about that name though. I'm not sure about that one. I don't know if Los Angeles would adopt it.
That was a pretty anti-Semitic joke there. All right.
Those do happen from time to time. Austin Heartless says, "I had a talk with a friend about politically incorrect sports team names sometime last year. It was a great time. Lots of laughter." CJ says, "Confirm Nick stands with Bullet. No, I do not." Timothy Reaper says, "The real Jews are African-American. I know because some weirdos on the street were shouting at me about it. Apparently, they was also Kangs." Scarfy the Strange says, "This feels like a Phoenix Wright case." David Edwards says, "I really enjoy your solo streams, but the guests lately have been great. I hope you have a lot more to come." Oh, we do, David. We do.
Beautiful.
Horatius763 says, "The law is whatever a judge says it means. Been that way since the beginning. Thomas Jefferson wrote that the Supreme Court was the worm within the apple." And then finally, Night of Hope says, "I have a theory on why briefs were so good and the delivery was so bad. They probably stole the previous legal team's work straight up, and they wrote nearly none of what was in those briefs. Probably walked in, didn't do the work, and didn't rehearse it." I don't think so.
I don't think so either. If you're someone who left his legal team, I don't think you give your work product over to Donald Trump's subsequent attorneys.
And if you're coming in, I can't imagine any lawyer going, "You know what? I'm just going to use this other guy's brief." Like except for Giuliani when he came in the day of the oral argument, and he doesn't have time to write that brief because he's being hired that morning.
You're saying the incoming people wouldn't take it. I'm saying the outgoing people wouldn't want to give it.
I'm saying both.
That's what. Yeah.
Would you take someone else's brief? Like,
if I read it over and it was this strong, I might. Yeah, like what you're gonna look a gift horse in the mouth and say, "No, I'm not taking that." But I don't think. I mean, then the question. It's an interesting question. Like, if he paid for it, can he say, "All right, you did work product, give it to me"?
Yeah.
If you want me to pay your bill for what you did for last week and give you $300,000 for putting together this brief. Well, first of all, when did they're responding to the House managers? When did the House managers come out with theirs? Because
like the day or two before at most. I mean,
this all had to be done in a couple of days. Right?
Yeah, I don't think they're using the other attorneys' briefs. I don't think the other attorneys had started briefing the case. I mean, they probably had some preliminary notes on it, but they're not actually hired at that point. Like we're talking about when the 5 attorneys left the Trump impeachment team. they weren't. I don't know if they were really much on the team at that point. Like
Yeah.
I'm not sure about that. So I don't think that's a likely outcome. I really don't. I mean, I think attorneys are scumbags, and I still don't.
If you're Bruce Castor and you want to pitch yourself to someone like Trump, and you want to pitch your firm to Trump, what you do is you basically come out with a role model as to what your brief's going to look like. That's a great way to pitch yourself as a great candidate for him to choose you to represent him. Like you actually invest, you might want to invest like dozens of hours into putting together a sketch of what this is going to look like and have a lot of the framework there before you even sit down for a meeting with Trump.
So you don't think it's a good idea in the interview to be hired to say, well, I don't really have anything, but what did your other guy write? Let's just look at that.
It's not your strongest move. It's not it's not your go-to move.
And finally, Bad Dragonite says, from the South, but don't know Ray Stevens. Smack my head. No, I don't. Sorry. All right, guys, that's the show for tonight. Thank you all for hanging out. We'll see you guys tomorrow. I'll be streaming 11 a.m. Central Time. We'll see how this stupid impeachment goes. Tomorrow, I will set up the live stream tonight. And if it continues to be interesting, I'll keep going. If it loses interest, I mean, I'm not going to keep covering it. But so far, it looks like it's going to be pretty fiery.
It'll probably get better. When you get witnesses, it's going to get better.
Yeah, I think so, too.
That's when it gets fun.
Plus, more people to make fun of. So
yeah.
And then tomorrow night, Joe will be back, and we will finish this document. You know, we read enough pages today to finish the document tomorrow, if we keep the same pace. So I think we'll do it.
We'll plow it through.
All right, guys.
Thank you, guys.
Yeah, thanks for hanging out. Go check out Joe's channel if you haven't yet. Go subscribe to it. We'll see you guys tomorrow. Have a good night. Peace.